Listing or
Yeah.
detail? Listing to detail.
Hmm?
Listing to detail.
May I please your lordship? I beg to mention item
Order to sign for e-learning.
Lordship, the problem which has arisen is that your lordship had disposed of the petition yesterday, directing a fresh process B.
I think that was a consent order.
Lordship, but our particular petitioner has become overaged, Lordship, by 2 years. So generally, the age limit is 55, Lordship, to apply for the post.
So what do you want? A matter to be heard on its merit?
Lordship may take it up on Friday, Lordship.
But it will be an infractious matter. Why should we decide a matter which is infractious?
Lordship may perhaps-
Even if I decide the right in your favor, we cannot direct them to complete it if they don't want.
Lordship may perhaps grant us liberty to appear for the investigation.
No, overage, I think there is a particular, that notification is there, I think. This is definitely it's a hardship
Lordship.
because you had raised an issue earlier that became infractious matter. So it's a good case to condone the overage limit. So for that, the remedy will be to make an application under the 1951 notification. You do that. But even if I decide the right in your favor, ultimately we can't compel them to continue with the selection process if they don't want to. That is another factor. But even if they apply, we can't compel them. I don't think we have to need a judicial order for that. Anytime we can make that application.
May I please your lordship? I beg to mention item
And if you want the order to be online, if you want the order to be recalled, we'll recall it and list it for hearing whenever you want. What do you want? Let's see, we have understand, but if he is not withdrawing the consent, we'll recall the order. We'll recall the order and post it for a regular hearing in the part 2. But we'll not continue with the interim order because the college is suffering.
He can apply no issue. College is suffering. Already 6 years is gone.
Option for you is we can recall the order, we place it for hearing, but without an interim order because we can't allow the students to suffer because of someone wants to become a principal somewhere.
We'll file an application.
I think that's better option for you. If they don't take it up, you file a fresh writ petition for that. Yeah. Yes,
May I
ma'am.
please your lordship? Lordship? I beg to mention item 47, lordship. I may be accommodated for a day now.
Okay, 47 is adjourn on the prayer room as the question.
Ji, please.
May please your lordship. Lordship, I beg to mention item number 17, lordship.
17.
My
Please give it there. Okay.
seat.
Call item number 1.
Item 1 for motion.
Mr. Mojumdar, I think this needs some hearing. Can we take up at a little later so that the other motion matters are not held up?
Because your lordship will have to pass an order of disposal, and take something, certain materials will have to be.
I understand. So we'll have to hear you on that, I think. Will it be inconvenient for you if
No.
I take it up later?
After your lordship finishes the first.
Let's see. Oh, we'll hear you today itself,
Well-
with a little bit of.
And I found out the notifications
Hmm.
whereby the tribunal is there. Silchar tribunal, the industrial tribunal has been given the additional power of walkout vote for all the 3 people.
Okay, so they should have gone to that tribunal.
Yes. So since these defendant, plaintiff should have gone. So therefore the decree will be a nullity. And since she has come in revision, possibly they will have to file a paper appeal before the first appeal court, not before your lordship under CRT. So you with.
No. This is where we got stuck on the last occasion.
My lord.
If it is an order passed by the appropriate authority, that is the tribunal,
Yeah.
then remedy is revision before the High Court.
Exactly.
If it is instituted in some other court,
Yeah.
if tribunal exists, other court does not have jurisdiction. If tribunal does not exist, other court may have jurisdiction. Then if it is the other court,
Yeah.
a general court, then the remedy against the order of the general court is appeal. So now this is a order passed by the general court, not by the special tribunal.
Exactly.
So remedy will be appeal. In appeal, we will take the ground that this is
Exactly.
this judgment is a nullity.
This is my step.
We'll make these observations, but perhaps High Court
Yes.
will not have jurisdiction under 115
Yeah.
because rightly or wrongly,
A degree
this
has
is
been
the
passed.
order by a
Civil code
by
and
the
decree
civil
has been
code.
passed.
Lordship, my one submission is.
No,
that
your
Only one,
submission of not on convenience, submission on law.
Lordship, on law point. Normally, when we prefer cases when there is no family court, Lordship, before district judge, that's because district judge is equivalent to family court, Lordship. Here also, Waqf tribunal is equivalent to district judge, Lordship. But this judgment was.
No. Waqf tribunal has been specifically designated
Yeah.
and this thing. It is not a district judge.
Lots of it take about sometime.
We'll hear you.
Right.
Don't worry, we'll give you a complete hearing.
Interestingly, my lord, trial court framed an issue also on this point about maintainability. They relied on a judgment of 2010. But after that, there was an amendment in the act in 2013.
Oh.
Thereafter, 2024, Supreme Court has passed another order overruling the earlier judgment. So
Okay.
that was not taken into consideration. I brought it here. Now tribunal has jurisdiction to decide even the eviction matter. This is an eviction matter. So it is a common. So tribunal will have jurisdiction.
Can you exercise power under 227?
Possibly not. One judgment I have brought in a similar matter.
Definitely not 115.
227 also not my Supreme Court is. I have brought the judgment. I'll produce for them.
They'll have to go in appeal.
I have
We'll
one
hear you.
submission, Lordship.
We'll hear you. Prepare yourself after hearing what Mr. Mojumdar is submitting.
Another CRP we have filed,
Let
Lordship,
us
challenging the.
take up the other matters. We'll hear you, madam.
Item 2 and 3.
May I please, Your Honor? My lord, for item number 2, the connected, my lord, item 3 is listed. My lord, what has happened in this case, my lord?
Item, you're moving item 2 or 3?
2, my lord, 2.
2.
Yes.
2 is a later one.
2 is a later one, my lord. In
Uh-huh.
fact, what has happened, my lord,
I should particularly, you are challenging, you want some direction for appointment.
my lord, in fact, there was a, my lord, earlier I approached this court, my lord.
Very well. And what about item number 3?
See, my lord, what has happened,
Hmm.
the petitioner in item 3, my lord, his provincialization was cancelled by the director by the same order whereby I was, my lord, provincialized.
Understand.
But, my lord, the stream, my lord, are different. In fact, my lord, the fray of
No,
the
but what happened to item 3?
3, my lord, notice has been issued, my lord. And,
Is there any interim order?
my lord, no interim order. What is, my lord, said that the provincialization shall be subject to outcome of the writ petition. That is the order passed by the honorable court.
So we admit
No,
your,
my lord, my case is totally different. What I'm trying to say, my lord, in fact, the fray of the petitioner is with other one. They belong, my lord, to language stream. I belong to, my lord, the social science stream.
are you a respondent in the other writ petition?
My lord, I am a respondent, but it has been decided by this honorable court on the earlier, my lord, round of litigation that virtually I have nothing to do with them, my lord. Because I belong to, my lord, the social science stream and they, my lord, belong to language stream. Even if, my lord, my provincialization is cancelled, they cannot get my post.
Who appears for item 3? We're appearing. Why have you made him a
Yes, my lord,
respondent?
exactly.
My lord, he was initially, my lord, discharged from the school, my lord. He was no longer a teacher, my lord.
No, that is another factor.
My lord.
But if you are a language teacher
My lord.
Your provincialization claim is against the
My
post of a language teacher.
My lord,
He is not a language teacher. So how you are aggrieved?
agreed, my lord, because my lord, the impugn order, my lord, declared that the petitioner, item number 3, my lord, is a junior to the my lord, other two respondent, my lord. Respondent in my case, my lord.
No, but even you are junior or senior, it doesn't matter because his claim is for a post of social studies,
Social science.
social science.
My lord, kindly see the page.
Because you can never be provincialized against a post of social science.
Exactly.
Even if you are senior,
My lord.
you cannot be provincialized. You will be
And-
provincialized against the quota for language teacher
His claim, my lord, is
My lord,
respondent 9 in his writ petition.
My lord, kindly see page 69, my lord.
of
Of
item 3.
number 3, my lord. Page 69.
Yes.
Operating part page 70.
Mhm.
My lord, these two
Just a
pages,
minute.
my lord,
Abdullah Khair is
is the, my
your
lord,
petitioner.
Yes.
Very well. And Mr. Talukdar, your client?
I am Abul Hassan, serial number 3, social
Abul
science.
Hassan. Just a
my-
minute. Abul Hassan.
My lord.
And who is respondent number 9?
9, my lord, is Sofiul Haq, my lord.
Sofiul
That is
Haq.
language. Both of them are language, my lord.
My-
Abul Akhir and Sofiul Haq.
Just a minute.
Yes, sir.
What is the date of appointment of Abdullah Khair?
Abdullah Khair, date of weapon is 1993.
1993. Sofiul Haq?
Sofiul Haq is also, my lord, 2002.
Huh?
2002.
2. So Abdullah Khair is senior to Sofiul Haq.
Yes.
Very well. And Abul Hassan?
Abul Hassan, my lord, he was appointed in 1998, but subsequently he was discharged due to long absence, my lord, unauthorized long absence.
No, no, my lord. This argument is not, my lord, tenable.
Mr. Talukdar,
Well,
please don't interrupt when somebody is submitting.
My lord, kindly see,
Because this is not a boxing match. That one punch is there, another one will be from the other side. This is a court of law. Huh? Let him complete it. They will hear you. Yes, Mr. Islam. Okay, he was discharged then.
discharged.
Huh?
Then, my lord, kindly
No,
see,
Mr. Islam. Suppose he is discharged also.
my lord,
He is a social science teacher. So in this school, no one can be provincialized against the post of social science.
my lord.
So what legal right of the petitioner is violated? And what right you have against?
No, my lord, social science teacher is, my lord, Sofiul Haq. My lord, kindly see page 69 and 70 is the my lord, operating.
We have seen it then.
My lord, is a my lord, my lord, unauthenticated page, my lord. Subsequently, it was rectified, my lord.
Which one?
My lord, kindly see then page, my lord, page 72. These two pages, 69 and 70 are my lord, unauthenticated without any sign, my lord.
No, it has the sign. It because that one ends in page 71,
Well,
signed by
page-
member secretary scrutiny committee.
Well, page 71 signed, but page 69 and 70 is unsigned. Then subsequently it was rectified, my lord. Kindly see,
Rectified means
rectified, my lord, it was changed and his name is not in the my lord.
who has changed?
Well, page 72 is the my lord order, my lord.
Just a minute.
My lord. Maybe manipulated, my lord. It's
This is a fraudulent document,
My
you mean to say?
my lord.
It's a serious allegation, Mr. Talukdar. Mr. Kaushik, produce the original of this page 69, 70 and 71. Mr. Islam, rightly or wrongly, he has made a very serious allegation that
The page 73 and 74 is the rectified page.
that the format for reporting, page 69, it is not signed. Page 70 is not signed. There is no initial also. Page 71 is signed. He says that page 71 is genuinely signed, but 69 and 70 had been fraudulently manipulated. Get the origin.
My lord, that is, then they are also rectified and the my lord, page 73 and 74 was replaced, my lord, with sign, my lord.
73.
3 and 74. And in 74, Abul Hussain name is not available, my lord. Two teacher, Abdullah
No,
Khan, language.
his client is Sofiul, not Abul Hussain.
Abul Hussain is Sofiul is Mr. I am for a subject.
You are for Sofiul. And oh, you're Abul Hussain. Abul Hussain is not there at all.
My lord.
Understand?
My lord. And my lord, kindly see the impugn order, my lord.
Hmm.
Impugn order is
Heard Mr. Yes, what do you want to say? We stopped you.
My lord, in the earlier round of litigation, these aspects, my lord, has been settled. Now, if you
But
allow-
Mr. Talukdar,
My lord.
1994, 1 SSC, page 1. Fraud vitiates anything. And even after confirmation by the Supreme Court, the issue of fraud can be raised at any stage before any forum at any time. So merely because earlier court it was not raised, that does not mean res judicata is applicable for fraud.
I'm not on that, my lord. If your lordship sees, my lord, the petitioner, the respondent, my lord, they did not, my lord, in fact, object. They have, in fact, my lord, consented to this part.
Very well.
In the
We
order,
heard,
if your lordship comes to page
so you
9.
are trying to justify fraud by consent.
I'm
Okay,
not
your,
saying
your next submission.
No, my respectful submission is there is no fraud. If your lordship, my lord, peruses the
So
record, I have no
definitely we
objection,
have
my
to
lord.
look into it.
Yes.
Because fraud is a very serious allegation and every court is bound to take it seriously.
Yes.
Ultimately, it may be rejected, it may be accepted, is another factor.
My lord, in the writ petition, I don't
Mr.
think
Kaushik?
that he has made any statement with your statement.
Mr. Kaushik, give us the, how this document came into existence. It was a genuine bona fide mistake by some authority or it is manipulated.
My lord, one submission. My lord, there is
We'll
no,
hear you on the next day.
there is
That
no
the-
statement to this effect, my lord, that these are manufactured documents.
even Supreme Court even ruled out that also. All technicalities are also ruled out. Fraud, just one line.
No, lordship will peruse it, man. I have no
You
objection.
read that Supreme Court judgment, fraud vitiates everything.
Lordship will peruse it.
Bas. At any stage, at any time. ঠিক হলো? Third, Mr. S.K. Talukdar, Land Counsel in WPC 488/1/2023, Mr. M. Islam, petitioner in WPC 6564564/2023, and Mr. M. Khan for the respondent number 9 in WPC 4564/2023, and Mr. B. Kaushik, Land Counsel for the Elementary Education Department. And Mr. B. Gove for SSA, for the Finance Department. WPC 4564/2023 has been instituted. A sealing. An order dated 26/6/2023, which page, Mr. Islam? Annexure 23, which page?
Page 99.
92. Assailing and assailing an order dated 26/6/2023 of the Director of Elementary Education Assam, by which, after conducting a due hearing of the parties, it had been held that the writ Mhm. 90, 90, it had been held that. No, it had been held that. Never again, you are using the word petitioner. See, when there are multiple writ petitions, everybody is a petitioner, and who you intend to mean by petitioner is not very clear. The authorities, why don't you use the name of the person? It's always safer. Whether he's a respondent or petitioner, in whichever, it doesn't matter. The name of the petitioner was recommended. But that doesn't mean you are not deciding a writ petition. You are deciding your own administrative order. Abul, when you held that, Abul Hussain was recommended by the DSC for provincialization as social science teacher in the Kesar Vita MEM.
My name was not, my lord, recommended. Therefore, I came to this honorable court on the earlier, my lord, round, my lord. Due to my name was not recommended.
Please,
My lord.
we'll hear you. No, not today. This page 98, who is, what is the meaning of page 98? That's what I am saying. That the claim of Abul Hussain had been accepted for provincialization as social science teacher. It was also held that Abdul Akhir Ali was appointed on 3/2/2002, and therefore he's a junior language teacher among the two language teachers of the school. Vis-a-vis Sofiul Haq, who was appointed as a language teacher in the year 1993. Are you right?
Yes.
Accordingly, the director accepted Abul Hussain for provincialization as a social science teacher, and the earlier provincialization by the order dated 4/2/2021 in respect of Abdul Akhir was cancelled. The Abdul Akhir instituted WPC 4564/2023, amongst the ground that the recommendation of the DSC, which was relied upon for accepting provincialization of Abul Hassan, is a fraudulent document. Mr. Talukdar, please take your seat. We are recording his submission, and you have no business to object or obstruct or dictating the order. He can submit anything, whatever he feels like.
Correct.
And why will you prevent us from recording his submission?
No, I'm sorry.
Please don't do it. Kikolu. Fraudulent document. Inasmuch as the said recommendation is available as Annexure 16, page 69 to page 71 of the of WPC 4564/2023. And out of the 3 pages, the pages 69 and 70 are unsigned document, which is alleged to have been manipulated and fraudulently entered, whereas page 71 is duly signed. Reliance is also placed upon Annexure 17, page 72, which is a communication from the Director of Elementary Education Assam, dated 8/8/2019. Wherein the director had dealt with the aforesaid contention that the last page was signed, whereas 2 other pages of the document were not signed. Reliance is also placed on Annexure 18, page 73, which is another report of the District Scrutiny Committee, wherein at page 74, it is noticed that the name of Abul Hassan had been deleted from the list of teachers recommended for provincialization. It is also the submission of Mr. M. Islam, Land Counsel for the petitioner in WPC 4564/2023, that the name of Abul Hussain rightly did not appear at pages 73 and 74, inasmuch as his services were earlier terminated from the school. He was earlier discharged from the school. Mr. M. Khan, and counsel for respondent 9 in WBC, also supports.
No.
You don't support. You object to Mr. Islam.
No, I'm not.
You what?
I'm not objective.
It does not object to the submission of Mr. M. Islam. Mr. S.K. Talukdar, in the aforesaid circumstance, Abul Hassan has instituted WPC 488/2023 for a direction to appoint Abul Hassan, to provincialize the services of Abul Hussain as per the, pursuant to the order of the director dated 26/6/2023. As there is a serious allegation of manipulation and fraud in respect of the document based upon which the order dated 26/6/2023 had been passed, we required the authorities in the elementary education department to produce the original record of the Annexure 16 document at page 16(9) as to whether it is a manipulated and fraudulent document or it is an acceptable document. If it is acceptable, further submission as to why the director had issued the communication dated 8/8/2019, as well as the rectified recommendation of District Scrutiny Committee as Annexure 18, page 73. This today is Wednesday, Friday. Get the record. We'll hear you. Let the record come. We'll hear you whatever you have to say. Right? Get it.
We will have to get it from the district,
Doesn't matter.
because the original record lies with the
District is South Salmara.
South.
Okay, Monday.
Sorry, Abhilash.
Please, Your Lordship, my lord, I may be allowed to point out one thing, my lord. My lord,
Do it on Monday. Why do
either
you?
it is a wrong recording or my lord, the fraudulent document, my lord. Wrong recording.
We have put both.
My lord.
Hmm.
Highly object.
Item 4,
No, it cannot be wrong recording. Somebody had mistakenly put it.
My lord.
If a discharged teacher had been included, some fraud must be there by somebody at some level. Yes.
This is the appointment for the laboratory attendant panel. Here the petitioner has qualified at the written examination and thereafter he was called for the documents verification. And during the documents verification matter, a notice was published, that is page number 23.
No, it came up before.
Yes, madam.
2% are sharing the first
Selected the
position.
time mark says.
Now, what method will you use for tiebreaker?
I have to obtain instructions, Lord.
No, it's already 2-3 months have gone by. We want the information, therefore we not issued notice. Or else if you want to know, we will go a little further, we'll allow the repetition also. No, notice we don't want, because once you issue notice, it will remain there for 5 years. We don't want to do that.
I will obtain
So
instructions.
deliberately, I have not issued
On that
notice and
point
want the
also.
information. And Mr. Gogoi. Mr. B. Gogoi. Both of them obtain same mark, first position. One post, who will you appoint? That is the issue.
They will have to formulate a methodology.
This is what I am asking. You formulate it and tell us, we'll apply it.
You can.
Captain, I will
Take up
obtain
after
instructions.
1 week.
Uh, You have to take a decision. Now, how will you, what law you want to apply? You cannot reject both of them.
Yes.
Because the two men are in the first position, you cannot reject both. Now, how will you decide between the two? Friday. One, you find out some other relevant, for appointment there may not be, but for other aspect, there are some principles. Suppose for promotion, I think, no, when you put up higher in seniority, two persons appointed on the same day, whom do you put up in the, whom do you put up high?
In case of promotion.
No, merit is equal. That is a difficulty. Suppose there are two persons appointed on the same day. You have to prepare a gradation list. One of them will have to make them senior. Both cannot be holding the same.
In that case, my lord, the seniority is determined by considering the merit list of their initial appointment. Say, my lord, whoever is in serial number 1 in the merit list.
But here that option is not available because this itself is the original.
They will have, my lord, they might be, they will have to see whether someone has got any experience, so he can be preferred over the other. Or some criteria will have to be, my lord.
Or else you do one thing. Best way out. Between these two first position candidate, redo the process once again. That is one way out. You subject them to some more intense scrutiny and find out what difference is there between the two and who is more preferable. This may be one way out. Other way out will be maybe one who is higher in age between the two. But difficulty is higher in age is not a principle already in existence. Now, after the issue has arisen, now if you adopt the procedure, it will violate the principle that you are laying down a procedure after the selection. Somebody may object to that. Friday. Best course, you go and appear before the selecting authority once again, both of you. They'll put you to some further test and try to find out who between the two will be more suitable.
But there is some direct recruitment for class 3 and class 4.
Understand. We understand everything. Yesterday there was a cricket match. Okay. What happens if both the teams score the same run? They put in one super over, they call, to find out who will be better. Face something in the nature of a super over before the same selection authority. They'll intensely scrutinize both of you in whatever manner. And whoever comes out better will be appointed and selected and appointed.
They are private respondent party in the without
No, he has not come before the court.
he is a respondent otherwise. He will be one of the affected party.
Understand? So why do you have to hear him? We are not taking away any legal right of his, nor he is before the court seeking to enforce the selection. Or else do one thing, serve dusty on the other man.
Friday it may be taken up in the meantime.
You serve dusty and the departmental authority also inform the other man to remain present before the court. I think that will be better.
Indicate the order will come.
Heard Mr. A. Boro, Land Counsel for the petitioner. Also heard MS D. Bora, Land Counsel for the respondents in the Health and Family Welfare Department. Full stop. Both the petitioner and the petitioner Himangsu Das and the respondent number 4, Nipal Kumar. Sorry. Now, All four are,
All
four are
equal
first
marks.
position.
Yes, equal marks.
All four got equal marks. In what? In the written
In the
test.
written-
In the interview?
The written, they have not said anything, but they are not qualifying the. Their name was not reflected in the.
You are now saying something different now. Issue notice returnable 6 weeks, extra copies 3 days.
So that we fix Melo on 11th of.
We are issuing notice. Steps on respondent number 456, registered post 3 days. Extra.
Item 5.
The other day you made a submission that both you and the respondent are finally selected and both are having same marks. Today your submission is little different.
Item 5.
Mr. Buragoy.
My lord, these petitioners, they're all qualified, my lord,
Yeah, I
pharmacists.
understand.
So now only problem is that we have not been registered under the state pharmacy council.
My instruction is evident. We have already communicated with the government. There is a direction to the government, my lord, to take a call in this regard, that in this situation, what they are suggesting to do. Because students are suffering. We have passed out, they are waiting for registration.
Definitely.
So, my lord, I pray. Lord,
No, what is the difficulty in registering them?
My lord, presently the Assam Pharmacy Council is not functioning. Elections have not been held because of
Acha, council is not
they will have to
functioning.
register it, like the bar council. Without that, they cannot. do, my lord.
Understand, definitely. Why the council is not functioning?
Some elections have not been held, some legal issues are.
Election. This is,
For constitution of the executive body.
no. Who constitutes this council?
It is
It's
by
an
the
autonomous council or
autonomous, my lord. Pursuant to the my lord, Pharmacy Act, my lord, this is constituted.
some pharmacy act? Huh? Which provision, Mr. Gogoi? Council
My lord, 19.
19. State government shall constitute.
So, A,
Huh?
six members.
State government shall constitute a council consisting of following members. 6 members elected from amongst themselves by registered pharmacists of the state. So, who is not doing it? They are not holding the election.
Yes, some issues are.
A registered pharmacist. Do the registered pharmacist has any association?
There are, not one, my lord, maybe more than.
That is the difficulty. You do one thing. No. Let the state government notify the election through a public notice. Ask all the registered pharmacies to come forward to participate in the election to be held on so and so date at so and so time.
But the process was initiated. The rule prescribes that, my lord, it should be by postal ballot. The government and the, my lord, pharmacy council.
No, where is that rule?
The state rule, my lord, that. But I can come up with an instruction on Friday, my lord. This Friday, at least 1 week.
No, what we are trying, let us trying to find a solution,
Yes.
because unless unnecessary, they will be affected. They are ready with completing the course, but they are not able to operate their pharmacy. So the right under Article 19 and 21 is violated.
Right.
And if the registered pharmacists are creating all the problem,
They are divided.
I know.
Ultimately,
Moment you said one line, I understood what is the problem. There must be different groups of registered pharmacists. Everyone claims that I am the original, he is the not. So ultimately you are unable to hold it, but they cannot hold the new pharmacist from this thing. Otherwise, we'll have to do one thing. 5 members from at least 3 possessing prescribed degree, 1 member elected from amongst themselves, chief administrative of the state, officer in charge of drugs and control, government analyst. So there will be 5, 6, 7, 8, 9. So if the council will comprise of 15%, it appears. 6 from the elected,
Yes.
5 from the clause B, 1 is from C, D, double D and E.
Yes.
So 9. Then we'll ask you to take up the issue by constituting a council comprising about 9% and declare that they will complete the quorum and take up their application.
Right.
And the registered pharmacists, leave it to them when they are ready to hold the election.
Okay.
They are ready to hold the election by, why should the state get into this dispute between the registered pharmacists? You have no business.
No, madam,
It's
I-
not your headache also. It is their problem, they'll solve it out. So they are ready to hold their election. They'll make an application to the state and state will facilitate the election. Until they don't do it, council will function with 9 members.
On Friday, madam, we will have the-
Or
Probably they will have to constitute a ad hoc council.
no, we'll direct you to constitute a complete council
Right.
with 9 members.
Okay.
Taking note that there's an infighting between the registered pharmacists and it is a situation has come, it is not possible to hold election. So till the infighting subsists and registered pharmacists will come to an agreement amongst themselves how to participate in the election, the council will function with the other 9. And moreover, if you see the composition, the more relevant people are the B, C, D, and E, not the registered pharmacist. The registered pharmacist is only it's like a trade body, whether they will allow entry of some new pharmacist or not to protect their own business. They are not very relevant. Relevant is the other one. They are all the technical officials.
In fact, except A, my lord, rest will be, my lord, nominated or by the government.
By the
election
government,
will be
only
for-
election. So you complete the process with B, C, and D. If you are unable to, timing will leave out A. With further provision that whenever their infighting subsists and they are ready to participate in election, they'll approach the government will facilitate the election. Or they'll hold election amongst themselves and inform you.
Let me have that question from Friday.
But
No point.
but statutory council cannot be hijacked by a few people in this manner. What will happen if the lawyers don't hold election and bar council stops? Can you conceive of that situation? Same thing.
On Friday.
Friday. List on Friday for further deliberation. Mr. B. Gogoi, Land Counsel for the Health and Family Welfare Department, states that as per Section 19 of the Pharmacy Act 1948, the State Pharmacy Council should also comprise of 6 members elected from amongst themselves by registered pharmacists of the state. It is stated that amongst the registered pharmacists in the state, there is infighting.
Will not be recorded. I don't have the written instruction. But
Okay.
when they are
That
holding the
it
election, I will
it
have
is
the-
stated that the registered pharmacist of the state are not carrying forward the process of holding the election to elect the 6 members. And therefore, the pharmacy council could not be constituted under section 19. The respondent to specifically, state respondent to specifically inform the court as to when the registered pharmacist of the state would be ready to hold the election by conferring with them. And if the registered pharmacists are unable to arrive at a consensus to hold the election amongst themselves, further consideration would be made that in such circumstance, how the state council can be constituted. This Friday for information.
Item 6.
Monday, let's be on Monday. If we will get little time to this.
Monday.
Friday will be better. So we are suffering from it. It is about 13 months. We are jobless, predicting the everything.
Let's be on Friday.
Obliged.
Friday. Mr. Riam Bhuya.
Earlier occasion, your lordship asked me to punish my lord judgment, my lord. This is the judgment.
What is your matter, Mr.
My lord,
Bhuya?
here, your lordship, petitioner before your lordship is a student, my lord. And he has changed his, my lord, original name, my lord. And therefore, my lord, he asked, my lord, proportional, the Seba, saying for, my lord, change his name is, my lord, certificate of HSLC, my lord. But it was denied, my lord.
Can it be done?
Yes, my lord, recently, my lord, Supreme Court one judgment passed, my lord.
What judgment Supreme Court has passed?
In this case, my lord, this Sebas.
No, which paragraph you are relying on?
My lord, lordship kindly see paragraph 170 to 172.
170, 172. No, before we look into, we'll definitely look. If Supreme Court provided, we'll accept it also. But on fact, this man is X as on the day he appeared in the examination. Later on, he changes his name and becomes Y. So this is a prospective operation of a fact. Okay. How can this prospective operation of a fact have a retrospective operation that as on the earlier date when he was X, now he should be called Y?
But here, my lord, regarding
proposition will be you obtain a particular certificate or document from an appropriate authority. We will certify that wherever the name X appears in any document in anything shall now be read to be Y, and Y should be considered to be the holder of that document. But changing retrospectively in public record, when factually on that day, when the record was entered, you are not Y, but you are X. Why should the court order that?
This aspect, my lord, Supreme Court, my lord, thoroughly, my lord, considered, my lord.
What did the Supreme Court say? When a student
My lord,
applies for prior permission.
Paragraph, my lord, 91, Sebas judgment was also, my lord, taken note of, my lord. Page, my lord, 600.
No, please point out the relevant paragraph.
Yes, sir. This
We
is
can't
the,
read a 100-page judgment now.
yes, sir. Paragraph, my lord, 610 page running, and my lord, paragraph 191, my lord.
191, you rely on that. Okay.
This paragraph, my lord, and operative part, my lord, paragraph 194.
190?
First, my lord, 191.
Mr. Borobhaya, tell us one paragraph which you want us to read. 191.
191, my lord,
And
194.
191 and 194.
194.
Please don't keep on changing.
Seva's husband has been mentioned here, my lord, this is time limit.
No, Miss. Okay, let me read it, huh? And 194.
94.
What is that 1872 Act referred there? No, one word is there, envisaged in 1872 Act. Which act is this?
1872 Act is for a civil matter, my lord, related to public document.
Evidence Act.
Relating to public document.
No, 1872 Act means Evidence Act, I think.
Like, public
Evidence
document.
Act 1872 no.
It is mentioned in this case also.
1872 is the Evidence Act.
Oh, yes. Reverting to the first case, there is some in relation to the public documents as emphasized in the 1872 Act. Public document, getting the public document like evidence. Thus, public documents therefore cannot be ignored by the CBA. Here he is referring to our case, 2003-12 STC. That appeal was filed by SEBA in 2003, Soripur Zaman. Correction of date of birth. The court ultimately, we have given 3 years time limitation that has been upheld by the Supreme Court, that it is the reasonable time. If it is open to all, then it will create some Pandora's box. That's why it creates some problem in the court running of the office. And also said the court had no occasion to deal with the circumstances when a person would want to change her name out of her free will in excess of or granted fundamental
No,
rights.
Supreme Court has allowed it. 194.2.
Paragraph is separate here, my lord.
Mr.
Allow is there's two conditions, my lord.
Mr. Chutia, please read 194.2 paragraph.
94.2, my
Read paragraph 194.2. Supreme Court concludes that it should be
yes.
allowed.
I have here letter.
However, in the later situation where the change is to be effected
Yes,
on
yes.
basis of new acquired name without supporting school certificate, that request may be entertained upon insisting of
Prior permission.
prior
or
permission declaration by a court.
Court of law. in
So
that
these
regard.
two documents you will see in that regard, and publication in the official gazette, including surrender, return of original certificate, duplicate issued by the CBSE, and upon payment of prescribed fees. Fresh certificate, as in other situation referred, retain the original entry except in respect of change of name effected in exercise of the right to be forgotten,
That is by declaration of.
and to insert caption annotation indicating the date on which it had been recorded and other details including disclaimer of CBSE. This is so because CBSE is not required to adjudicate, nor has the mechanism to verify. In light of the above, we direct CBSE to process for correction or change, as the case may be, in the certificate. So Supreme Court has said to direct to process it. You process it.
Process, that means there is a process, this is process. If the Supreme Court says.
Mr. Chutia, Supreme Court never asked you not to follow any process. You follow your process and do it.
But there is no provision in our SEBA's regulation.
But this is
a SEBA, CBSE.
This is a law laid down by the
CBSE, the rules is not a statutory rule. It is a bylaws. And our rules is a statutory rule under the Act.
Mr. Chutia, this is a law laid down by the Supreme Court
Yes,
under 142.
Yes, I have
And a law laid down under 142 will prevail over all other laws.
Yes.
So your submission that ours is statute, CBSE is a bylaw, so therefore Supreme Court judgment not applicable. I think we will have to reject this argument.
I am saying, however, the saying by declaration of the court of law. This is the civil court says a declaration is obtained, then he approves. Then they will process.
Declaration of law regarding change of name. Not declaration of civil court directing the CBSE to do it.
No, my lord.
Civil code, not civil court also, whatever is the official, prior permission, declaration by a court of law in that regard. That means regarding the change of name. That X has now changed his name to Y. And not only that, publication in the official gazette. That change must be published also in the official gazette. If he satisfies these three conditions, you do it. If he does not satisfy, reject it. But you cannot say, I'm not going to process the application in view of the Supreme Court judgment.
No, as per our regulation, we reject it. We inform him that we cannot do it because there is no provision that we cannot do it. Now he says this case says, then we will file an affidavit to that extent. Lordship may to notice because I think, my lord, no, I will file affidavit because we deny it. We deny it because I will interpret it.
Day after tomorrow, Friday, whatever you want. List on Friday, Mr.
Friday, my lord.
Yes, awesome. It's pending for almost a month now. You should have filed it by now. The issue involved in this petition is that the petitioner has changed his name from
Abdul Hussain to Laskar to
Abdul Hussain Laskar to Ayan Akhtar Laskar,
Absolutely.
and accordingly made an application before the respondent SEBA for change of his name in the certificates issued by the SEBA. The SEBA, by the order impugned dated, which order? Where is the rejection order by the SEBA?
Page
51.
47, my lord.
47 by the order dated. This is some inadvertent mistake. By which order? Mr. Chutia said they had rejected. By which order?
Prior to that. I think, 43.
43.
I would like to paragraph on that part was rejected as
had rejected the claim of the petitioner for incorporating changes in the certificates as per the communication dated 12/6/2023 by providing that as per the regulations of the board, such prayer is time barred. It is further fortified by Mr. T.C. Chutia that the regulations of the board are statutory regulations and they do not permit for any change of name as claimed for. And therefore, the rejection is a valid rejection under the law. But Mr. A.M. Borbhuya, learned counsel petitioner, relies upon a pronouncement of the Supreme Court rendered in Jigya Yadav versus Central Board of Secondary Education and others reported in 2021 7 STC 535, wherein in paragraph 191, the Supreme Court distinguishes the two situations regarding correction of name in a certificate issued by the board, which crept in due to an inadvertent clerical mistake, and the other situation where on a free will, the person concerned changes the name from one name to another name. The change of name of a person on free will from one name to another name had also been recognized by the Supreme Court to be an act in exercise of the fundamental right of a person. Accordingly, in paragraph 194(2), it had been provided that in a situation where the name had been changed on a free will, and thereupon there is a request before the board to change the names in the certificates issued by it, such a request may be entertained upon insisting for prior permission stroke declaration by a court of law in that regard, meaning thereby regarding the change of name on a free will, and further publication of the same in the official gazette. And in doing so, the boards are required to effect a surrender stroke return of the original certificate or duplicate certificate as the case may be, and upon payment of prescribed fees, a fresh certificate be issued by containing the changed name, but by retaining the original entry through which the certificate was issued. Mr. T.C. Chutia, learned standing counsel for the SEBA, has raised a contention that the judgment rendered by the Supreme Court is in respect of CBSE, who are governed by certain bylaws, whereas the SEBA is governed by statutory laws, and therefore the pronouncement of the Supreme Court would be inapplicable. It is noticed that the aforesaid declaration by the Supreme Court appears to be a law made in exercise of the power under Article 142 of the Constitution, where the interpretation would be that a law framed by the Supreme Court under Article 142 would prevail over all other laws, inasmuch as such laws are framed for the purpose of rendering complete justice in a given matter. Mr. Chutia at this stage prays for an adjournment to file an affidavit on behalf of the board. Prayer allowed, list on Friday for the affidavit.
No, I don't, my lord, I will, my lord, be available on 4th of December, my lord.
Monday, for further consideration.
Public.
Item 7.
But the affidavit must be confined to this one. Don't make those all 50 pages affidavit bringing everything. Only this question, whether the law laid down by the Supreme Court will be now binding on the board or your statute.
It is apparently a binding, my lord. I am not saying like that.
But Supreme Court, what do you do? Or you go to the Supreme Court and they challenge it that it was incorrect.
I will have to go through the facts of your case of your case.
But you will have to produce your declaration, firstly. Declaration through a court of law that there is a change of name. Secondly, it must be published in the official gazette. Only then we'll ask them to entertain.
I have
As the order of the Supreme Court also requires
to pay fees like that.
A precondition of it requires a precondition of prior permission stroke declaration by a court of law as regards the change of name, and also publication of the same in the official gazette. The writ petitioner to also produce relevant materials which may substantiate the prior permission stroke declaration of a court of law as well as publication in official gazette. If you don't, we are not issuing the direction.
7,
791 accommodation notice that in fact just I have.
Adjourn on the prayer, Mr. Assembly General Counsel, for the
Second
say,
next week look into that.
to be listed next week.
Next week.
Hatari. Item 8,
Now again. Yes, sir.
Yeah, please.
HMR. Posting this.
Matter pertains to constitution of managing committee. Previous managing committee, term of previous managing committee expired, my lord, then a general meeting was held, my lord.
What is wrong with the new committee?
No, my lord, after the name of 2 persons were proposed in the general meeting, my lord, but the head teacher forwarded the name of only 1 person. Then the villager lost a complaint before the authority. And also it is by separate order, the forwarding of the names by the head teacher for constitution.
No,
of the-
no. His case is little different. Head teacher, the 2 names are required to be forwarded, and 2 names were selected by the public and all. But the head teacher committed a mischief. He forwarded only 1 name.
But even if he forwards 2 names or 1 name, he has no authority to do it.
He may
because
not. No.
Under the,
Mr. Kaushik, there is a situation little different.
no, but if I clarify.
From the other cases, this one is different. Headmaster, by sending 1 name, had precluded the other name from being considered by your authority.
But we cannot consider the names which is forwarded by the headmaster. Because under the RT Act, in a school, elementary school, well, this is an elementary school, not that notification which will cover the secondary school. Here, my lord, election has to be conducted. By way of an election, the SM managing committee has to be constituted. It is not that the general.
Okay, so now you held the election.
The DO has already directed the headmaster to conduct the election. Now
what is he challenging now?
his grievance is that the election has not been conducted.
Not been held.
Not been. And he
Conduct
has,
the election.
yes, and he makes an apprehension that the name which was forwarded by the headmaster will be approved. It
In
cannot-
the election, anybody can contest.
Yes, anybody.
You go and contest the election.
Yes, please.
We close it.
My lord.
Heard Mr. AMHR Chaudhary, Land Counsel for the petition, also heard Mr. B. Kaushik, Land Counsel for Elementary Education Department. The petitioners herein are all interested in the constitution of the School Managing Committee of Sorai Hagi Hekenamari LP School in the Morigaon district. One of the grievances raised is that the public of the locality had recommended 2 names for the purpose of being the president of the school managing committee. But the headmaster of the school had forwarded only 1 name, thereby precluding the other recommended person from being considered for appointment as school president of the school managing committee. But Mr. B. Kaushik, Land Counsel for the Elementary Education Department, points out that in respect of an elementary, in respect of a LP school, the appropriate procedure is not for the public to recommend name and the headmaster to forward it, but to hold a direct election between the interested persons who intends to participate in such election. Accordingly, by the communication dated
Page 19, my- page 19.
19. Accordingly, by the communication dated 2010-2023, the Block Elementary Education Department
Another.
had, please don't interrupt, had directed the head teacher of Horai Hagi Hekenamari LP School to conduct the election and submit the list of the managing committee members to the Block Elementary Education Officer. As the required procedure under the law is to hold an election, and Block Elementary Education, by the communication dated 2010-2023, had already directed the holding of election. We are of the view that the ends of justice will be met on a direction being issued to the Block Elementary Education Officer to ensure that the elections are held at the earliest and not later than 1 month from the date of the order, of today's order. And whenever such elections are held, the due procedure of law be followed, and the writ petitioners, if they are interested, may participate in such election.
Item 9.
Yes, madam, item 9,
If the lordship matter relates to completion or tampering.
DLC,
DLC, placed before the DLC but should not consider.
page number,
Page number 30, Doctor.
sorry,
30,
13. 13,
30, 30.
30. Where is the petitioner? Rokibul Islam. Where is the rejection?
The page number 30 last.
Down below, your lordship.
Page number?
Recall Islam,
30, 30.
Page number 30.
30.
Yeah, this is after 1 year. Consider it. They
Ah,
have already passed a number of judgments on this.
yes. that
This is no limitation act is not applicable. That 1 year, 1 day gone, you are out.
Yes, just lordship may record my submission that it is, this matter too is barred by laches and delay and it do not meet the purpose of completion appointment. Lordship at page 16.
Okay, we'll give.
Page 16, your lordship.
Heard, we'll give a reason.
Yes.
Heard MSS Khalifa Land Council, but it will cause more trouble to you.
Lordship.
Once
page-
you record the reason, it will be more trouble to you.
May so, yeah.
Okay. We don't mind. We'll give a reason also. We are rejecting it, but that reason we are giving may create a little more problem later on. Because they'll take advantage of this order subsequently. Up to you. Otherwise, we are passing a simple order that this is no longer res integra, that this 1 year period is directory, not mandatory. There is a judgment. Only on that ground we are setting it back. But if you raising those submissions to be recorded, we have to give a reason why you're rejecting your submission, and that reason may go against you little later.
May I get page 16, your lordship? Page 16.
Okay, I'll record it.
Page
Heard the MSS Khalifa and Council of Petitioner also heard. Mr. B. Devry, Land Union Advocate for Deputy Commissioner Borpeta, and Mr. B. Kaushik, Land Counsel for Respondents in the Elementary Education Department. The father of the petitioner, Ainal, what vote is in Change for dear. Huh? And Dutaman already the whole visit to. The father of the petitioner, Ainal Hawk, was the head teacher of 1127 number Bogulmari LP School, died in harness on 7/11/2006, and on his death, the petitioner submitted an application for compassionate appointment on his death. The mother of the petitioner submitted an application for compassionate appointment on 1/2/2007. But the said application did not result in any favorable consideration in favor of the mother. Subsequently, the petitioner, who was a minor at the time of death, made an application on 25/7/2016 upon attaining majority. The application of the petitioner of 25/7/2016 was considered by the DLC of Borpeta district in its meeting held on 1/10/2021, and it stood rejected by providing that the application was not submitted within a period of 1 year from the date of death. Admittedly, when the petitioner was a minor at the time of death, and further, when it is stated that the mother of the petitioner had made an application within 1 year of the death, but the state application did not result in a favorable order. It is not a situation where the application of the petitioner is to be rejected for having not been submitted within a period of 1 year from the death. Inasmuch as in the circumstance, the petitioner could not have submitted such application as he was a minor at that relevant point of time. The aforesaid situation had been considered by the Honorable Supreme Court in Khadim, and a proposition had been laid down that where the mother makes an application for compassionate appointment within time, but no favorable consideration was made, and subsequently the son, upon attaining majority, makes a application at a later date, such applications are not barred by any time limit. In view of the above, a proposal law laid under Supreme Court, the rejection by the minutes, in the minutes of the DLC dated so-and-so, rejecting the application of petitioner on the ground of having not been submitted within 1 year of the death is set aside, remanded back to the DLC for fresh consideration by taking note of the proposition laid down in Khadim.
If some report went wrongly, Your Lordship, the page number 20, Your Lordship. Now my elder son, namely Raqibul Islam, is under age, so I pray your kind authority to appoint him on compassionate ground after attaining majority. She is keeping the reservation for her son, making the application to that extent in the year 2007, reserving for her son. Not that she has made.
Khadim takes care of that. Khadim takes care that law doesn't prevent. We see Mr. B. Dewry further raises an issue that the application of the mother was in fact for an appointment in favor of the minor son when he attains minority, and that is not permissible in law. We agree that it is not permissible in law to make an application on behalf of a minor son for appointment after he attains majority. But at the same time, compassionate appointment is offered to remove the financial burden that the family of a deceased employee may face upon his sudden death. Merely because the son was a minor at the time of death, and the son later on happened to grow up to become a major to claim a compassionate appointment, itself does not depict any factual situation that the family of the deceased was very well off financially during the intervening period, so as to arrive at a situation where compassionate the benefit of compassionate appointment is not available any further. In the instant case also, nothing is noticed that the authorities had made a factual evaluation about the financial condition of the family of the petitioner and arrived at any satisfaction that they were financially well off during the intervening years, so as to disenable the petitioner for a compassionate appointment.
Secondly, at page 16.
Every line you add is going to...
Only second submission, Your Lordship, that mother and the elder sister could have applied because die-in harness scheme, Your Lordship. So their hardship mattered.
It's submitted that the mother and the elder sister of the petitioner could have also appeared, but there is no material available that they are duly qualified for a compassionate appointment, so as to entertain such submission.
Item 10.
Lordship. Your Lordship, yesterday's matter, that Karimganj matter, Your Lordship.
I did not sign one matter.
Yes, I communicated with them, Your Lordship. Perhaps Your Lordship is right in the apprehension and the presumption.
But I have forgotten what we was.
That is that that DLC has not taken all the aspects into consideration, that the financial comparative part. So Your Lordship was right in the presuming that because that
Mr. Dewry,
that's the complete deal. I'm giving, so Your Lordship can
put it.
Case goes in the favor of petition.
Okay, thank you. Mr. Dewry, entire difficulty with compassion upon what you know. If you do it correctly or in the original stage, what you are required to do? Follow the High Court judgments. There are 10 applicants, there is one post. You make a financial statement of the respective candidate. Whosoever is worse off, give it to him. If you actually do this, I'm telling you, no court can interfere with your decision. But difficulty is they don't do this. Ultimately, they find out, make a pre-selection who is to be given. And now how to justify it? Reject X in this manner, reject Y in the other manner, reject Z in some other manner. Ultimately, we recommend so and so. And in doing so, the illegality becomes a little apparent. So you give the scope to the court to interfere. This is the bottom line, nothing else.
It's helpless.
So therefore, by making all kind of submissions, you are unable to defend this action because the original action itself is unsustainable.
Sometimes we too feel that the needy one has not got the
There's
justice.
no one is getting, it's become almost like an
That is
industry
very-
now.
For a state of affairs.
But if you do the core requirements, produce that order before us, tell me which court is going to interfere. Did you ever find us interfering with this appropriate finding of the authority?
No.
In which case you tell us the court had interfered, that after making a proper assessment, the court has still interfered? Not a single case. This is where the malaise lies. Another mischief you do is, suppose in one DLC, vacancy is found, a man is recommended. It should go to the SLC for its approval, normally.
Yes.
What you will do is, you'll club up 5 different recommendations of 5 different DLCs, send it to the SLC in one go. Now the SLC will start making a comparison, whether to give it to the recommended man of the first one or to the second one. Other day, one matter happened. The first DLC recommended one man, rejected another man. Unscrupulously, the rejected man was placed before another DLC, subsequent one. Both went to the SLC together. SLC approved the rejected one, first rejected one. And the one who was actually recommended on merit, he was rejected. These things keep on happening. Why do you allow it to happen? Don't you think on a closer scrutiny, all these illegalities can be detected? It can be easily detected. Just you apply your mind and look at it in the manner what you have done. This is what we are doing.
Your
Next
lordship
item.
is right in approaching after
Next
coming
item
from
now.
DLC.
So
SLC should not have any
you
business.
take corrective measures at your original end, everything will be all right. Item 10.
Similarly, regarding midday meal,
Sorry?
midday meal. Earlier, there is a midday meal,
And who is the petitioner?
SMC.
SMC.
Actually, my fact is like this, Lord. Earlier, there is an order of amalgamation, and that order was challenged.
Merger, that the 2 schools are merged.
Yes.
Ah.
And your lordship passed an effective order. Thereafter, Lord, this SMC is now okay. There now is 2 years, 3 years period, Lord, for they have constituted 2 years passed. 1 year is again, that is up to September.
No, that's okay. So now what is
Now their function has been closed. But there is no any order. Right?
See, if I understood Mr. Rashid, 2 schools were merged. Merger was challenged.
Right.
That challenge was allowed. Ultimately, the merger is interfered. That means the original identity of the 2 school remains.
Yes.
Now, this is the SMC of one of those schools.
All of them that.
And that SMC is not recognized by the authorities for the purpose of midday meal.
Midday meal.
This is your grievance.
Right.
This is not his grievance. His grievance is that there was an amalgamation order. He approached the High Court. High Court directed the authorities to reconsider their appeal, their grievances with regard to amalgamation. And till the reason order is passed, that amalgamation order is stayed.
That's a normal order we passed.
Yes. And till date, there is no violation to that order. Now, he is aggrieved by the page 36 letter, communication of the DEO.
What is it?
This is a general communication by the communication to all page 36. this lordship will read this date as 30/08/2023, not 02. 08. Malad, this is a communication to all the deputy inspector of schools, directing them to constitute the SMC, which is going to expire on October 2020. His case is, my lord, but I can understand.
What is your prayer?
Setting aside this communication.
Why?
Yeah, as because my lord, by the end of this order, my lord, our committee, my lord, is not able to work. Our no rise is given to our school, and the fund, my lord, which was
No. This is a order requiring reconstitution of the SMC in general all over the state, because the term is for 3 years.
Yes.
And 3 years is about to be over. They said you
And whose
reconstitute.
term is going to expire on October.
1 year left again in our school. But
1 year left.
that means like it was constituted one.
In your individual school, 1 year is still left.
1 year is still left.
Okay, we'll exclude your school from this one.
Yes,
There is
But why will I set aside the general
Yes.
order?
no, not general order, only for our school it should be there. Our school should be. But they have
Where is the constitution of your managing committee?
that is a page 35 million,
Yes.
35.
Base
33 is that has to be and 30.
Page 35.
Page 35 million handwritten copy and 33 million that is
Okay. Heard Mr. Ray Rashid, Land Counsel for the petitioner, also heard Mr. B. Kaushik, Land Counsel for the Elementary Education Department. Anybody else responding? No.
My lord, no. The correspondent number 8 headmaster is there.
Considering the nature of the order proposed to be passed, no notice not required to be issued to the respondent number 8, who is the headmaster of Uzirechor High School in the Borpeta district. The SMC of the school headed by the present SMC of the school of the Uzirechor High School was constituted as per the order of the District Elementary Education Officer Borpeta dated 16/9/2021. It is, please don't interfere. It is stated that under the rules, the term of a managing committee is for 3 years, meaning thereby that up to 15/9/2024, the present managing committee of the school would have its term. Petitioners are agreed by a communication dated 30/8/2023 of the District Elementary Education Borpeta requiring the Deputy Inspector of Schools Borpeta to make necessary arrangement for constituting the new school managing committee. Full stop. It is stated by Mr. B. Kaushik, Land Counsel for the Elementary Education Department, that this is a general order pertaining to all the schools of Borpeta district, on the premises that in most of the schools, the term of the managing committee is likely to come to an end by October 2023, and therefore, in order to provide a seamless SMC of the school, there is a urgent requirement to reconstitute it so that upon expiry of the term of the present SMC, the new SMC can take over. But Mr. Rashid points out that the SMC of the petitioner school was constituted on 16/9/2021, meaning thereby its term would continue up to 15/9/2024. In view of the factual situation, which is different in respect of petitioner school with that of the other schools of the Borpeta district, we provide that the communication dated 30/2/2023 shall not be applicable in respect of the SMC of the petitioner school, that is Uzirechor High School. And while providing that in respect of the other schools where there is a requirement to reconstitute this SMC, the communication would hold the field. In respect of the petitioner school, upon prior to its expiry, the authorities would be at liberty to take appropriate action for reconstitution of the school. disposed of in the above terms.
Correction, but there is, lordship would like that, Muzir sir, there should be more for the sir in Madras.
Not high school.
Yes.
No, this page is high school. Which page did I look into?
Now, there is first year lordship declared one thing, like there is a SMC Mokwa Zero Sir, ME Madras, not high school.
No, no, which page it was?
Just, the,
You pointed out
First-
one particular page.
the lordship has declared the description.
Please point out the page from which I had.
On Millet, there is a first Millet cause letter, or synopsis. Synopsis still Millet. And also Millet
No, no, it's Mokhwa, huh?
and also Millet.
No, just a minute. Mokhwa Ujirates or MEM, huh? ठीक है. Steve Bourbon, appears correspondent both.
In the meantime, one thing, that it will be now, it will continue, but in the meantime, only disputed company from the system. In the meantime, rice was taken by the headmaster of the high school, again returned to us, but the amount that is cost for the midday meal rice millet, that is in the now going to the account of the headmaster of the high school. So we are not able to operate. So we will be
That is
allowed
not a
to-
challenge in the report.
No, that is something like good, no?
You find a new writ petition
There
on
is-
the other cause of action.
And also.
No, what you are saying is right.
You know?
After the merger is being stopped,
Right.
you are entitled to your own rice,
Yes,
but the headmaster of the high school is taking away all the rice.
kindly see me, Lord,
And
page 27.
Must be giving a little amount to this school.
Page 27, Lord, I have received the same rice from their school.
But there is no prayer as such.
Yeah,
Nothing is
only
there.
that we allow function, so we will be able to everything. And the amount also going to their account, not our account. For the.
It
cost
is
of-
stated by Mr. A. Rashid, learned counsel for the petitioner, that the what
Moko, Minister, in Madras.
Mokhwa Ujirechor Emi Madrasa was earlier merged with the Ujirechor High School, which was assailed by the petitioner in WPC
5440
5440
20.
2023, wherein there is an order that the grievance against the merger be raised before the authorities in the government, and till such a decision is taken on the grievance raised, the merger shall not be given effect. Pursuant to such order, it is stated that the Mokhwa Ujirechor Emi Madrasa is presently independently functioning, but the headmaster of Ujirechor High School, taking advantage of the earlier merger, is usurping upon the quota of rice under the midday scheme meal, which the Mokhwa Ujirechor Emi Madrasa is entitled. Full stop. The petitioner SMC or the petitioner school to approach the deputy inspector of school Borpeta, and the deputy inspector school upon such approach,
We filed a plea.
and if if such approach is already been made, to look into the aspect and ensure that the quota entitled by the Mokhwa Ujirechor Emi Madrasa is provided to them as per the procedure, and the deputy commissioner should also ensure that the headmaster of the Ujirechor High School do not interfere in any such process. Anything more?
Only quota plus fund. Fund it should be there.
Money
Otherwise,
also.
fund is the fund, they cannot dispute rice.
And other funds.
Fine.
That headmaster may be doing that also, you don't know.
Actually, they are neighboring persons. I have also known to them, they also known to me. Some,
But both are known to the money and the rice. So everybody wants to get hold of the rice.
that is the real thing. Anyway, must.
Order no steps, item 11.
1 week time may be given.
Sorry,
For steps, my lord, 1 week time may be.
Mr. B. Raman, I have praised for 1 week time to take the necessary steps. Pray aloud, just after a week.
Fine.
Impletement of party item 12.
Lordship, can you take up the matter next week? Lordship, I want to file one.
Adjourn on the prayer of SP Bacharji, Land Council for the applicant in IA 2066-2023.
Next week.
To be listed next week.
Item 13 for admission.
Yes, madam.
Lordship, I'm appearing for respondent number 7. Lordship, please, I beg to pray 2 weeks of time to be granted for filing additional affidavit.
Your name?
Okali Sema. Okali Sema.
Okali Sema, Land Council appearing for respondent number 7. Prays for 2 weeks time to file the affidavit. Pray aloud, list after 2 weeks.
If I point out,
You don't want Okali Sema to file an affidavit.
Lordship, the matter has been heard substantially. It has only on the point, Lordship, we sees the order dated 12/10/2023. It's only one point.
Who is the respondent number 6? Who is
7 is a
respondent
private
number
respondent.
6? Huh?
7 is a private respondent, Lordship. That is the person who is holding the post of principal as of now. We challenge that the issue is related to BA degree being
Rejection of B.Ed degree of the petitioner.
of the petition.
So you are not a necessary party, we delete you.
Yeah, private.
Sorry. No, he is not required to be heard. He is not a necessary party. Here is a legal right of the petitioner being violated upon the B.Ed degree not being recognized, where under the law it should be recognized. So it's a dispute between him and the authorities who is not recognizing it. He may be appointed, but he is an incidental beneficiary of this dispute. 1975 or something Supreme Court. Incidental beneficiary is not a necessary party. You don't have to hear him. That man does not have any audience of hearing whether his B.Ed degree is a valid or not. If it is valid, consequence of law will follow. If it is not valid, but once we declare him to be valid, if you want to act upon that degree, and the 6 will be adversely affected, then you will issue notice to him. Not, he has no audience to answer his dispute.
Lordship also arrived at the decision on that. Only
Because this issue is, we have already decided it.
Lordship has decided.
Because some institutes have not made the application within some time. People are not recognizing the B.Ed obtained from them. But the law says a little different, that it should be recognized. That's the issue between him and the authorities. And at the best, that NCT.
Lordship, also on 15th/11, they have saw the same prayer, Lordship, for the affidavit.
Sorry, madam, who is your senior?
It's the SDAS appeal.
Eskedas.
Lordship,
You are Eskedas.
yes, not Lordship, my senior.
Eskedas, where is he?
Lordship, from last night, he is suffering from highly fever, Lordship, due to which he could not appear before his honorable court, Lordship.
No, but what kind of a right of hearing you have regarding his B.Ed degree? You have nothing to say. We are not bound to hear you.
Lordship, on the last occasion, your honorable court, last line, raise a point.
Eskedas seeks for adjournment to examine the aforesaid proposition. You examine and tell us. No affidavit. When will he become well?
Lordship, Friday.
When will he recover from fever?
Lordship, by 2 or 3 days, Lordship.
2 or 3 days. List on read for further hearing. It is stated that Mr. Eskedas is unwell today, but no affidavit.
Highly obliged, Lordship. Highly obliged.
And mind you, tell Mr. Das, we are not bound to hear you. There is no requirement of law to hear the respondent.
Highly obliged. Highly obliged, Lordship.
অলপ আৰু দুটামান কৰি লওঁ নেকি কাৰণ 15 কৰো দিয়া।
Item 18.
May I please know? This matter relates to appointment on compassionate ground, my lord.
the petitioner mother was working as in the grade four.
Compassionate ground. Was it placed before DLC?
Yes, my lord, it was rejected, my lord, considering the rejected because petitioner is the junior candidate, my lord.
Junior candidate, where is it? Page number?
Page 31, my lord. Yeah, SLC.
SLC.
Page 31, Roman 4, my lord, below.
DLC recommended.
Because DLC recommended.
SLC rejected.
Rejected.
Which page?
Page 31, my lord, of my petition.
31, huh?
Roman 4, my lord. Below.
But it is because of lack of vacancy.
There is the, my lord, being the senior most candidate, my lord.
There is no seniority here. This is not promotion.
That is why, my lord.
There's nothing called seniority.
Considering the, my lord, seniority petitioner case was rejected, my lord. And I have made the parties, my lord, in this case also. They are subsequently they are appointed, my lord. Earlier, obviously, my lord, state was in tax to.
Just a minute. Where is the DLC recommendation?
DLC, my lord. Recommendation. Order. My lord, page 25, my lord.
It is noticed that the SLC of this period, they have lost track of what is originally required under the law and deviating somewhere else.
Yes, sir.
Especially this period, 2014.
14,
I have noticed.
13, 14.
And
They are
particularly this
Yes.
chief secretary when he was the chairman. We are not revealing the name, but you take note of the name. Especially this time, every decision of the SLC is in deviation of the law. Possibly the chairman was not even aware what is required to be done.
That is the
He
problem.
doesn't know what he is to do.
Even today, also,
And well,
the chairman doesn't know what is going on in that.
Doesn't
They
know.
are only presiding the meeting, lordship, but entire thing is done by member secretary or.
Then he should take control of his secretary.
Yes.
That doesn't mean,
That's
what will you do
Yes.
today if I allow everything to be decided by my secretary and my court
Yes.
master and everybody? I will just preside here. I will not do anything. They will come and tell me, it is a crock. Oh, okay, rejected.
rejected. That is.
Will you like it if we come down to that level? Then why is he presiding? He can at the best take the inputs of a secretary, but he'll apply his own mind and do it. Where is the recommendation?
Page 25, lord.
Page 25, my lord.
DLC are not enclosed, lordship.
Just a minute.
7 was appointed after expiry of.
Just
2
a
years.
minute, Mr. Counsel. He was so excited what to do with
Sorry, my
you.
lord, sorry.
DLC minus is not
Page
enclosed.
25. my
Where
lord.
is the DLC?
DLC recommend forwarding letter is there, my lord.
This is the
No, where is the
forwarding.
recommendation?
No, I don't have,
That
my
is
lord.
not there.
Produce it. The respondents to produce the recommendation of the DLC by which the petitioner, by resolution DLC by which the petitioner was recommended for compassionate appointment with reference to the communication dated 24/10/2023, page 25, annexed D. It appears that when the recommendation was placed before the SLC in its meeting of 1/4/2014, it stood rejected by taking recourse to a method that some other candidates were found to be senior to the petitioner. The SLC, the mandate of the SLC is to look into the correctness of a recommendation made by the DLC, either to approve it or reject it. If the SLC deems it appropriate to club many number of recommendations by the DLC at different stages, and thereafter venture into finding out who is senior amongst the recommended person, such procedure would be an aberration of the prescribed procedure of law. If he is recommended, you examine whether he is rightly recommended or wrongly recommended.
But lordship, petitioner also not to approach the court lately, lordship, 2019, lordship. It is the case of 2019.
Every case it is there.
Yes.
See, look it from the other point of view. Had the family being financially well off, they would not have come to the court after 5 years. When they feel that they still have that hunger to overcome, then they feel what is one possibility there, come to the court, let me try there also. Look at from the more positive point of view. Instead of drawing a presumption that for 5 years you have not come, so you're financially well off, draw the presumption they are financially not well off, therefore they deemed it necessary to come to the court. Why can't we draw that presumption?
And not since 2017 compassionate appointment, that scheme was lordship, top lordship.
So that this is before 2017.
Subsequently, lordship, the chief secretary has issued a notification lordship that the matter which is left over for consideration, that matter can be placed before the DLC lordship. Because of that notification lordship, lately lordship, the old cases lordship, they are lordship placed before the DLC lordship.
No, there is a general order of the government. All pending compassionate should be disposed of as per law.
Yes, sir.
So, moment it is your decision,
Yes, sir.
the objection to raise of delay is gone. Because it is your own decision. They're all pending. All pending does not prescribe any time limit. I think I have read that notification. One notification is there.
Yes.
We are following your notifications.
Yes, sir.
Produce it, we'll examine whether it was duly conceived. If not, we'll send back to the SLC.
20 and 21.
21. Yes, Mr. Mannan.
Right, in these matters, your lordship, the first matter, mainly the petitioner who has applied for the post of assistant professor.
No, today
in the
what
Postal-
what do we do? Today what do we do?
Lordship, I can leave it to lordship because they have already filed their affidavit and it's ready for.
Early hearing date may be fixed.
List on so has agreed, and everywhere should be made to give a final consideration.
May I pay? Lordship, they have filed two affidavits, but copy have not given to me.
You raise it at the time of hearing, will not look.
I have filed it, I have given copy to them.
Mr. Mohanto, when you hear you raise this objection, I'll not allow him to rely on those affidavits. If he doesn't give you a copy, you will not allow him to rely.
22,
But we
23.
cannot compel him to give you a copy.
Mostly.
Yes, yes, what is to be done?
Lord, the matter related to Miller, selection and appointment in the PTC Miller regarding Arabic code. And Miller, we are madrasa that qualified candidate having specialization in the Arabic Miller. And that's why Miller preference has been given in the advertisement also that those who had the Arabic Miller will be required Miller. Now, Miller, till date, no affidavit has yet been filed. In the meantime, we participated and select list is also prepared.
You want to file affidavit? How much?
3 weeks.
3 weeks. 3 weeks. Mr. S. Bora, Land BTC prays for 3 weeks to file an affidavit, pray aloud. A list after 3 weeks, but he also take the objection raised by Mr. A.R. Bhuya that although the selection process is over and the select is prepared, the appointment of petitioners are being
On hold.
affected as because the affidavit has not been filed.
Item 24.
You have the above. Respondents in the BT to ensure that the affidavit is recorded before the next return list also. Yes.
Please, your lordship. Lordship, maybe part in another day, my lord. Or my lord, this history is also pending.
Oh, here on some other day.
My lord, actually, what had happened, my lord? By
No, we
filing this
understand.
application.
His submission is let it be heard on another day.
My lord.
Are you objecting to that prayer?
No, I am not.
Then we hear it on another day. Today, after hearing you for a few lines, will not serve any purpose if he is not ready. When do you want?
Next week.
As prayed for by Mr. S. Das, Learned Counsel for the Higher Education Department, list on so and so. Mr.
M. Dotto.
M. Dotto, Learned Counsel petitioner, expresses urgency in the matter.
My lord, I am not expressing any.
You are not. Then you'll heard on list on so and so.
Item 25.
25. None appears for the petitioner, adjourned.
28,
Here, the petitioner is not selling the.
Understand, you are ready today? Adjourn on the prayer, Mr. U. Sharma, Land Council, Secondary Education, to be listed again on. Yes.
item 29,
What, you are ready or what? But I understood that you are not ready in the way you said. See, if you are ready, I can hear, but otherwise I don't want to just spend the time. Yes, sir.
Because the damage is not, he is out of station.
Adjournment.
Adjournment.
Your name, please. Your name, please. Adjourn the prayer of Mr. P. Ahmed, Land Council for petitioner on the ground that Mr. J. Ahmed is having inconvenience.
Kindly fix for here.
Take a date.
30 and 31.
Take the date from the court master. Yes.
Maybe.
Consolidated compilation you have made.
It's consolidated compilation.
Have you submitted it?
No. In my case, not it.
No, we,
Yes, no,
other order was, it appears different document annexed appear in different pleadings in.
Lordship, today I will submit it because I have prepared it.
Okay.
I have not filed it.
Pursuant to the order of 10/10/2023, the petitioner provides a copy of the consolidated compilation, which is kept on record. List on switch.
It may be come on there next week.
Okay, list on as paid for.
For respondent number 6.
You also take note of the compilation and refer to that.
Item 32,
Service of the petition has been terminated, only issuing the notice without any procedural.
Sorry.
Petition has been terminated from service, only issuing the notices without following the statutory provision. That is.
Can you hear it today?
I am ready, Lordship. Other side, Guwahati University.
Mr. Fukan was here sometime back. Where is he? PJ Fukan?
Yes.
Ask him.
After.
Sound key correct.
34,
Mr. Saikia. Mr. Ki Gogoi, 3 weeks time to file affidavit. Mr. K. Gogoi seeks for further 2 weeks time to file the affidavit just after 2 weeks. Sorry.
January 22, my lord.
He's retiring. Mr. Ayat Saikal and Congress states that the petitioner would retire in.
No, he says that it was filed on
Oh,
January.
file.
Who will file, Lord? Who will file?
Last opportunity.
Who will file?
Suppose he does not file.
No, on the basis of.
Let's see. Next day we'll see. This is the second time we are giving time.
35,
Mr. Gogoi, ensure you file it.
Lord, will file. Lord.
35 is appearing. Yes, Mr. Islam.
Please, your lordship. My lord, is a my lord matter relating to the my lord against appointment and the selection of my lord chairman, SMDC my lord.
Chairman SMDC of
Well,
high school, LP school?
High school, my lord.
High school.
High school, my lord.
So now who is been appointed?
My lord, the respondent number, private respondent was my lord.
You appear.
Yes.
You appear for the private respondent.
Yes.
And now, is there any stay order?
Yes, your lord.
You are enjoying a stay order.
Yes, your lord.
You are not holding the post. On
My lord,
who appears for the state? Are you ready with the hearing? Huh? I know your file. Are you ready with the hearing? If you're ready, we'll hear it. If you're not ready, we'll give you time.
Do it. No. It would fit.
On what ground you have challenged?
My lord, kindly see, my lord, 27 page,
Page 27.
page 27. Operating part is page 28, my lord.
28.
The table, my lord, serial number 1. One local educated, reputed citizen having no political career.
He should be the president.
President, my lord.
And now,
My lord, he is
now
not
who
a-
is appointed as president?
My lord, he is not a, my lord, local resident. He is a, my lord, belongs to another district. It is Kukrazar. His school belongs to the Dhubri district, my lord. So, my lord, this is the only issue, my lord. The
How
person-
do you substantiate he is a man from Kokrajar?
My lord, he admitted that he is a, my lord, resident of Kukrazar. It's
Only
affidavit and-
800 meters from the school.
The distance doesn't matter. Resident of the same place. So if you are a resident of another district,
My lord,
it cannot be the resident of the same place.
Distance more or less from the boat.
Where is the provision that if the distance is about 800 meters, you become a resident of another district?
Regarding the local personalship, instruction was sought for from the government. Who is the local person?
Who is the,
Local person.
what instruction? By which order? Hmm. Yes, I think government has to answer. Secondary education. No, we have asked you, this is your rule. That the person must be one local, educated, reputed citizen having no political career. Who do you understand to be a local person? What do you mean by a locality?
my lord, page 95, where the, my lord, inspector of the school said that the person of other district cannot be a president, my lord. Page 95. In an RTI reply. Page 95.
Why are you so interested to become president in school of another district? You go and become president of a school of your district.
I am also from the same area. And
Doesn't mean.
distance
So
of-
tomorrow, if a man from Bangladesh says, I'm also a citizen of India because I'm from the neighboring state. I reside only a few meters away from the border. Will the government of India accept it?
Our students are also.
That doesn't mean. Your students may go. Students have no limit. A student from Bangladesh can come and read in India. There is no prohibition in that. But a man from Bangladesh cannot come and claim here, post here, saying that I reside only a few hundred meters from the border. This is political division. What to do?
Other jurisdiction have name.
Otherwise, where is Mr. Sharma? Are you ready or we have to? Question is already set. How much time should we keep on giving you? Issue raised in this petition is that the respondent number 6, who is a resident of another district, but claimed to be residing within 100 meters of the border of the district, 800 meters from the border of the district, also claims to be a local person in respect of FA Memorial High School, which is otherwise located in the Dhubri district and not Kokrajhar district. In the circumstance, we are required to give a meaning to the expression local person, whether a man from another district, howsoever near he may reside, would be a local person of another district. Let's Master of which school? Mr. Kaushik, one headmaster is not appearing, although notice served. Can you ask the director to instruct him to come to the court? Otherwise, his matter will remain unattended. And possibly the headmaster will have to bring in some records, a correction of that name.
I can inform the inspector of school.
It stated that the respondent number 3, the headmaster of Bajani Gopal Gopalnath Balika Vidyalaya is not appearing before the court, although notice had been served. It is also stated by Mr. D.K. Roy, Land Counsel for the Seva, that the presence of the headmaster along with the records would be necessary in view of the issue raised for correction of the name of the petitioner in the certificates issued by the Seva. As the headmaster by his non-appearance is obstructing the further proceeding in the court, we require the Director of Elementary Education, Inspector of Schools, Nalbari, to take up the matter with the headmaster of so-and-so school and ensure his presence before the court on the next returnable date. List on so-and-so.
7.
My lord, the administrative department has opined, my lord, that service can be regularized.
No, but no affidavit has been filed.
No, my lord, no, I have not received any affidavit.
You want to file affidavit?
Finance.
Secondary Education Department and Finance Department.
Regularization has been refused by the finance.
So I think we'll have to hear them. Mr. M. Bhuya appearing for the Finance Department, prays for 4 weeks time to file the affidavit. Pray Lord, this after 4 weeks.
38, 39.
Lordship may peruse the last order. That is
University Law College.
6/10/2023. The university was asked to produce the records regarding the establishment of the constituent college, University Law College, as to what is the nature of the college.
You were appearing for the university.
For respondent number 4, Lordship.
4, who is
Yes.
made the in charge.
Yes,
Yes.
he has handed over charge to another person. That's the,
You have already handed over.
yes, sir.
Why?
And the other person.
No, why did you hand over?
That I do not know. She said that now she was overburdened because she's also the head of the.
Head of the Department of Law.
Law college.
Ah.
So
she does not want to discharge.
Yes.
So you don't have any submission to be made in this
Yes, Lord.
claim of the petitioner. Now, who is the in charge?
In charge is one Jagadish Sharma, I think. He has taken over. In that,
Secretary of the university classes then. This fact has been just.
So are you required to make the new person a respondent?
Yes.
Professor Jagadish Sharma.
What happened?
Just take it.
In earlier occasion, the same very person, Mr. Sharma, who holds the post of secretary to the university classes, he was given charge earlier.
Ah.
earlier. Then I challenged it by filing a writ petition.
And that was set aside.
Then that time they again withdrew that order, University of. And it given the search to respond.
This one. Now, when you challenge this, again given to that one.
She has given it and taken it too. This is how they are going on.
You know, regarding
Jagadish Sharma gave Mr. Mohanto's client challenge. When it was challenged, it was given to Madam Chaudhary's client. Now, when Chaudhary's client is challenged, it is again given back to Jagadish Sharma.
Sir, I'm not aware of this.
I think that is what the Alliance and Council is submitting. What do we do?
And maybe Milord, some pressure, maybe.
I know, we are not on anything. How do we proceed? Is he now required to be made a respondent?
Milord, he will be.
Because Madam Chaudhary's client is made a respondent, thinking that the order may adversely affect her client. Now, she says, I have handed over to the Jagadish Sharma.
He'll be a vital.
So, from that point of view, maybe Jagadish Sharma has to be implemented.
Well, this is only to buy time because I am retiring only after 1 month. So this is how. Well, in my actual submission, under such a situation, there is no necessity of bringing because university will be supporting him. It is in the during the pendency of this petition.
I understand what you are saying.
University has made this end.
Petitioner would be retiring in February, Milord, within 3 months.
This is how this modus operandi kindly say.
I understand what you are saying.
Yes, that university support his case. How they are making all these changes?
You comply with our earlier order, university to directed to produce the records resulting in creation and bring into existence university law college, as well as the legal status. That is whether it is a department of the university or it is an independent college. If it is an independent college, possibly in charge cannot be from the department. It has to be somebody from within the college.
Exactly.
If it is a part of the department, it is for the university to make anybody the in charge.
I have just received the note, Milord. A brief note has been prepared. It dates back to 1914. Milord.
1914.
110 years. 1914. That at that time it was our law.
Our law college.
In 1948.
Mr. Mohanto has submitted. We recorded it.
Yes.
That initially it was Earl Law College,
yes.
Then came to existence Guwahati University, and the Earl Law College was managed by Guwahati University.
Yes.
Thereafter, around 1974, Government of Assam deemed it appropriate to carve out Earl Law College from the control of the Guwahati University and named it Government Law College. And it started to function at a location outside the university. And presently it is BRM. In 76, university authorities, after Earl Law College came out, deemed it appropriate that Guwahati would also operate a law college, which is University Law College.
No.
Now, what is the legal status of this University Law? It's a department of the Guwahati University or it's an independent college?
Milord,
this is what we want to know. Produce the reports.
Brief note, Milord. In 1989, the Executive Council resolved that it would be a deemed department. And as such, the promotional avenues as applicable to the other departments provided in the Guwahati University Act, Ordinance, Statutes, Rules, etc.
Just a minute. If I heard you correctly, resolution is that it is a deemed department. That means it is an independent department. It is not a part of the law department. Because any deemed university, suppose X is a deemed university, that deemed university cannot be part of Guwahati University. It has to be independent. So once you have resolved it is a deemed department, it is an independent department. Once it is an independent department, it is separate from the law department. So a man from law department cannot be made in charge.
But it is under the faculty of law. So
no, it cannot be under the faculty of law.
I don't have.
It is a deemed department.
I don't have that.
So this is University Law College is like any other department. It is like the law department. It is like the physics department. It is like the biology department. That means it's separate from the law department.
Because others are postgraduate department, this is undergraduate department.
If your instruction is right.
Lord, I would require some 2-3 days
Uh-huh.
to go
Instruction
through the
is not
exact
that.
resolution.
University Law College is a part and parcel of the law department.
You know.
It is a resolution, it is a deemed department. Deemed means it is an independent department.
And there is another provision, my lord. The head of the department will be, my lord, from reader or professor.
No, those other things will definitely
Lord, I
examine.
have to go through the records of the.
Because
Yes, my lord.
Mr. Phukon, the issue raised is, if it is part and parcel of the same department,
Yeah.
then any of the departmental official can be made the in charge. We have to accept that. If it is not a part and parcel of the same department, but on the other hand, it is an independent department
Yes, my lord.
or an independent entity, then a person of the law department cannot be made a in charge. Like a man of chemistry department cannot be made the in charge of the physics department. It has to be within the physics department. Same thing. Subject thought may be of similar nature, but the identity of the department has to be different if I go by that resolution. Think over it, tell us, when do you want?
University Authority came to
Next
know
week,
about
Lord,
your lordship's order dated 6/10/2023.
Hmm.
They ought to have provided those records instead of giving a note sheet.
Get the records.
They ought to have given it.
Get your
And in the meanwhile, they have made a change again.
next week.
Earliest, subject to your lordship's comment.
7 key bar. Wednesday, the 26th of the 20th. The university authorities to produce their records as required by the order of 6/10/2023. Which pertains to creation and bringing into existence the University Law College. Which may indicate as to what is the legal status that has been given to the University Law College. The records are not available today, but Mr. P.J. Phukon, Learned Standing Counsel for the Guwahati University, refers to a resolution of the
Resolution dated 24/5/1989.
24/8/5/1899
24/5/1899
of the Executive Council, wherein it had been resolved that the University Law College would be a deemed department. If the University Law College is a deemed department, the respondents in a university to make their submission, why it should not be construed to be a department separate from that of the law department. These two issues we have said.
For further hearing.
on
Wednesday.
Wednesday. On 6th, most of
On
it.
6th. May I pray little indulgence so that the matter is listed in the upper part, the first half, subject to your lordship's board.
I don't know.
That will help us to get it resolved.
But if I do that, I hearing for a long time, the motions and all are impacted. Many people keep waiting for that. Because today also item number 1, I deliberately deferred because if I take up, it will take about a couple of hours. And moment I do spend 2 hours in item 1, others are impacted.
True. Well, immediately after motion.
May I
Let's see,
submit
we'll
one,
take
my
one.
lord? My lord, under my lord section 8B is a appeal provision to the vice chancellor.
The same section 8B.
8B.
One we use for that dispute law college.
Yes, my lord. And today also another case is there, item 52. My lord, they have not,
That lordship will
has-
decide.
But that is an emergency power. This is not an emergency situation.
Yes,
This is a situation
yes.
where the status of the entity of the government law, university law college has to be looked into. And after hearing, as we confine the issues, narrow down the issues, if it is a part of the law department, maybe you can require anybody from the law department to be the in charge HOD or principal or whatever nomenclature is given. If it is not a part of the law department, it is an entity which is something distinct and separate from the law department. Then law department personnel cannot be made the in charge. It has to be somebody from within the university law college. We'll basically hear on this.
Section 8B to be read with section 35.
No, but
that
that is
without
that,
exhausting that remaining.
no,
my lord.
that is a
Otherwise, my lord, there will be a roadblock. Section 15, my lord, that reader and professor status. So, my lord,
no, we are not going to the other questions.
Discretionary power.
We are not going to other questions. We want a factual records to be produced. What is this Guwahati University Law College?
But from the post should have been given, filled up as the in charge basis.
Whether it is an entity independent of the law department or it is a part and parcel of the law department. That's all. We'll decide only to that much.
Yeah.
The rest will leave it
The rest will follow.
the authorities.
All right.
Because suppose Guwahati High Court and Meghalaya High Court. If Meghalaya High Court is a part and parcel of the Guwahati High Court, the judge from Meghalaya High Court can also be the acting Chief Justice. If it is not, you cannot. Same principle.
Yeah, exactly.
Yes or no? For making the in charge, you cannot bring somebody from outside unless there is some further reasons and justification for doing that.
But the vice chancellor also cannot go against their provision.
You need not go. We are not asking him. We are asking the vice chancellor to produce the records so that we can examine whether it is part of the law department or it is separate from the law department. That's all.
This court may also like to consider that aspect, whether reader or professor or.
No, we have not yet heard that issue till now, so we don't know.
It is still a lecturer, but he
Yeah,
is going to retire in February. my lord.
It's a-
So, my lord, some
One is
compassionate-
one aspect is a broader issue,
You know.
whether it is a part of the law department or it is not a part of the law. Suppose it is not a part of the law department, then the broader issue will be decided that somebody from within the university law college
Yeah.
can only be the in charge.
Yeah.
Whether this man is entitled or not, that is the second question. We are not going to that question till now. It may be such that it has to be internal, but the petitioner is personally is not qualified. That is another aspect. That call you'll take it. We leave it to you.
15 second phase, first phase, whether is a team department or.
What is their power? Where from they can bring in? What is the pool?
Under.
That's it.
And deemed department has thrown some answer. It is a separate department.
Yeah.
Because Cotton College was a part of Guwahati University earlier, affiliated to Guwahati University. It became a deemed university. It's no longer affiliated to Guwahati University. It's a university of its own. Same principle will be applicable.
Oblige.
40.
Matter pertains to amalgamation of exclusive matter. And the inquiry was ordered, my lord. Page 64.
Mr. B. Kaushik, Learned Counsel for the elementary praise for 2 weeks' time to file the affidavit. Pray aloud list after 2 weeks. We need their affidavit.
41 for orders.
My lord, till then, my lord.
Was it passed earlier?
No.
Then file I. If it is there, we'll continue it. Interim order. If it is not there, file I.
We have filed their affidavit. For now, I think some adjournment, they have taken some decision for regularization of our cases.
Adjourn on the prayer of Mr. B.P. Bora, Learned Counsel for the writ petitioner.
If they regularize. Alright.
42.
My lord, regarding service respondent number 9, my lord, we have taken thus service. We have also
Have you filed affidavit?
Yes, sir.
Where is the affidavit?
My lord, we have filed it on 19/9/2022.
19/9.
This headmaster personally received the same.
Who is that? Some Upadhyay or something?
Yes,
Basudev
yes, he
Upadhyay.
is the headmaster.
Huh.
Okay.
By the order dated 9/9/2022, the petitioner was also allowed to serve dusty on the respondent number 9. Accordingly, an affidavit dated 19/9/2022 has been filed, bringing on record the notice issued by the registry, which contains the endorsement of Basudev Upadhyay, who is the respondent number 9. Accordingly, service on respondent number 9 accepted. List again.
43.
May I pray, Lord?
Review.
Lordship, can this matter may be adjourned for the day, Lordship?
Adjourn for?
For the day, Lord.
Adjourn on the prayer of Mr.
R.S. Wrongham.
R.H. Rahman, Learned Counsel for the
R.S. Wrongham.
R.S. Wronghan,
Yes.
Wronghan, Learned Counsel for the KAC.
44.
22. The office note indicates that no affidavit has been filed after
No notice can be served.
15/11/23.
Notice on respondent number 2 served or not?
But 2 served, it is for respondent number 4. First, taken.
No. Respondent number 4 served or not? Madam Chotia, you have to answer. It is served or not? Order to the Kadiyoge. Read the last 2 paragraphs.
Even prior to Kodu.
Mr. MSS, Chotia and Counsel for the elementary. It prays for some further time to provide the information as to whether notice upon the respondent number 4 had been served through the respondent number 2, as reflected in the order dated at video.
Few weeks for this one. Next,
46.
item 46.
In this case, we have an IA manner that was allowed for impeachment of the respondent.
Sorry, so 5 to 11. Yes.
So accordingly, we have also submitted the amended procedural manner. So Lordship may issue notice on the respondent 5 to 11.
In view of the implement of respondents number 5 to 11, as per the order dated 4/8/2023 in ISC 1974/2023, issue notice on the said respondents by registered post within 3 days. This after 6 weeks.
48.
48, yes, Mr. Wallinder. Review.
Lordship, finally, come to para 3, page 13.
We are dismissing this review petition because future events taking place after a judgment is delivered will not render the earlier judgment to be illegal. Suppose today you have ₹10 in your pocket and I pass a judgment with 10 you cannot purchase this particular pencil, so I dismiss your case. Tomorrow, can you file a review saying that today I have ₹100 in my pocket? No.
But
is the same principle not applicable?
Lordship, one thing, Lordship.
Review is maintainable only when, even after due diligence, certain existing fact could not be brought to the notice of the court, not future fact, or some relevant provision of law escape from being pointed out.
Here in this case, Lordship, embargo of 4/12/2018 is not there in the parent judgment.
Sorry?
Lordship, kindly come to page, Lordship.
No, before coming, what is your submission?
Sufficient, Lordship. Here embargo is imposed by the
Embargo-
order dated.
By embargo, who imposed embargo?
This Honorable Court, while passing the order, it is directed that the pensionary benefit is to be released from the 4/12/2018. That is not there in the WPC number 1089 of 2000.
I have not understood anything.
Lordship,
No, I have not understood the ground for a review.
review, Lordship.
Or you
there-
file a writ petition, we get a notice in that.
Lordship, in this case, Lordship.
Where is the order under review? Let us
Lordship,
take
that is Lordship.
page number,
13,
page number 13.
Lordship, para 3.
What is wrong with this order?
Lordship, that is a date imposed,
Key?
given Lordship,
Where?
a date is given 4/12/2018, para 3,
Para
last
3.
line, para 3,
Huh.
page 30.
However, it is also been provided in subsequent judgment that the requirement of not deducting 6 years would be effective from 4/12/2018 when the earlier judgment was.
First.
What is what?
This date is not there in the earlier judgment. That is judgment dated.
No, no. However, just a minute. You mean to say that there is no subsequent judgment? Produce a subsequent judgment. There is one judgment, we know. There is one judgment which had clarified the earlier judgment. That
I have an X. That I have an X. And this is the current judgment. Based by the Honorable Court while passing the order dated Lordship review, order dated Lordship 1/10/2010.
You have got the complete relief. Why do you want a review for nothing? Why are you creating problem for your clients? There's a specific order to pay the pension without deducting.
That is
So
correct,
if-
Lordship. Only condition imposed is that
No
he
condition.
is entitled for pension from 4/12/2010.
Where is that condition?
That is the Lordship para 3. Page 30.
No. However, the requirement of not deducting, not deducting 6 months.
6 years would be effective from 4/12.
But we have allowed your prayer. We have said.
Allowed, but that is from this date. That's why.
Heard Mr. L.R. Mojumdar, Learned Counsel for the petitioner. An issue has been raised as regards the last sentence in paragraph 3 of the order dated 1/10/2020 in WBC 3708/2020, which is extracted as below. By referring to the said sentence in para 3, stand is made that the petitioner would be given the pensionary benefit only on and from 4/12/2018. We do not see any such provision in the order, but however, on the desire of the petitioner, the order dated so and so stands recalled. List the petition for its consideration as per its own merit. Next item.
49.
Review allowed. That's why I told you, we are creating more problem for your client. Now he'll not get pension for next 3-4 years. Very well. Be happy. I think it should be referred to the Bar Council for professional misconduct, Mr. L.R. Mojumdar, for doing a disservice to a litigant who had got complete relief from the court, unnecessary filing a review.
No, Lordship, that is not. Actually.
Mr. Mojumdar,
on
what?
the basis of this, Lordship,
Mr. Mojumdar, after reading the order, twice or thrice we are expressing it. Don't say no.
Lordship, kindly have a look at,
We are not going to look, you go and argue before any other court.
Anything wrong on my part? Lordship?
It's completely wrong on your part as a lawyer.
Lordship, kindly have a look at this.
We are referring you to the Bar Council. So, look.
Agreement.
Sorry, Lordship, actually, otherwise I have.
We are referring to one council. You argue with there that you have not done it. A man who got relief in 2020 for pension, we are more concerned because a litigant is hankering for pension.
I'm not pressing, Lordship.
Definitely not. The mandamus is clear. Without deducting 6 months, 6 years of service, you will be paid the pension. And you are giving a twisted interpretation to the order and trying to file a review, getting it recalled. Now that poor litigant will not get pension for the next few years. Is this not a professional misconduct? And what else is this?
I'm the apology for that. Lordship, actually, I'm saying something. I'm not.
Definitely not. See, we also have a responsibility towards the litigants, not only toward Mr. L.R. Mujumdar. Just because he files a review, we have to. Why did you file a review, first of all, as a lawyer? Read the order once. Mr. Argesh, please read the order. Show him the order. And show it to Mr. Chisti also. They have got a habit of giving twisted interpretation to everything, and ultimately you're bringing downfall of your own client. Read the last paragraph of the order, the effective one. Yeah, next to the
49.
49 the speaking order is passed.
Yes, Mr. Chisti, is there anything wrong with that order? Does it need a recall? It's an order of 2020. A man is really getting pension. Now in 2023, I recall that order. It'll take another 3-4 years for that petition to be decided. So who will be responsible for the poor litigant not getting the pension? I don't know what is going wrong. Do you know the law of how to read a judgment? Are you aware of it, that law? Only trying to increase the number of cases in your chamber, nothing else. That's why I said it's a kind of a professional misconduct. Nothing else. You should do acts for the benefit of your client, not for the detriment of your clients. Yes. Mr. Chisti, please look it once again. Is anything wrong with that order? Can the order be interpreted in any manner? This man is not going to get the pension, and that to complete pension. Then your pension will also be withdrawn if I recall this order. This is wasting time. Yes, what is it?
Contempt petition.
Contempt.
The speaking order.
You're closing it? You file challenge that?
I do not know what speaking order.
You need not know. If the order is wrong, remedy will be a writ petition, not to continue with the contempt.
Only what are my lord, page 10, my lord, last paragraph. Page 10.
Yes, I think so, if a better sense prevails with you. Because if you're getting complete pension, I recall this order, tomorrow your pension will be stopped. Because pension is as per the court's direction. Now, what will happen to your client once a pension is stopped? Hmm? And that observation is also a very right observation. There is a later judgment which says that the earlier judgment will be given effect only from that date. Check up. Wait for some time, after some time.
Page 10, my lord.
Hmm?
Page 10. Last paragraph from bottom.
This is not adequate.
The direction was to director. Now director cannot comply with, therefore director has recommended it to the government for compliance.
Then you have to file for a
For implementing the government.
no, for a recall of this order or a modification of this order.
Because director do not have the authority.
Right or wrong, referee is directed to take for release. It's a
Release.
positive direction.
And director has,
It's not a direction to consider and pass an
Consider and
order.
pass.
It's a direction to release.
in fact, the speaking order, your lordship will find the last line. Director said that for proper compliance, director has recommended it to the government.
But that is not good enough.
But here director,
I think it will be little inadequate.
madam.
This contempt petition is instituted alleging willful and deliberate violation of the order dated 1/11/2022 in WPC 5293/2020, by which in paragraph 8 thereof, the respondent number 3, that is the director of Elementary Education Assam, had been directed to take steps for release of the arrear financial assistance to the petitioner school for the period 2010-11, 2012-13, 2013-14, and 2014-15. Full stop. In compliance thereof, an order dated 6/6/2023 of the Director Elementary Education Assam has been produced before the court, wherein it is provided that the funds that were allotted for the aforesaid years had in the meantime lapsed and had gone back to the government, and therefore the matter had been referred to the government. We cannot accept the order dated 6/6/2023 to be a compliance of the direction in the order dated so and so. If the order is unimplementable on the part of the Director of Elementary Education Assam, and the direction is specifically to the director for doing the needful, it would be appropriate for the director to file an application for modification of the order dated so and so, rather than unilaterally sending it to the government. The government will now say, we are not binding. It is not a direction to us. Ultimately, he will not get his money. The order dated 6/6/2023 is returned back to the Mr. B. Postal and Council for doing the needful.
Item 50.
My pleasure, Lordship. So I'm praying for 2 weeks time for filing affidavit in reply to the.
Under prayer of a 2 weeks time to file affidavit reply. Any urgency?
Not from my side. They are seeking
2 weeks.
some benefits. From my
So-
Lordship, there's an office note stating that we have not filed the. We have filed it on
Okay, no, it's taken note that the respondent number so and so had filed the affidavits.
51.
As per lodging report, service on the respondent number. As per lodging report, service on respondent number 5.
That
Completed.
postal track.
Postal date consigned.
Hey, can you hear me, sir? RKD Chaudhary? Just now he went out. He met to get there.
Sorry.
Huh?
Friday. Monday.
Oh, আজি নহয়. Okay. That the postal department, we want to raise that issue. It's on 4th, I have been told. No?
Oh,
The service of notice.
yes.
Please do something about it. Repeated matters are coming now.
I'm taking it up today.
Other day, I think again, secretary to the government of somewhere that also could not be served. What we intend to do, you also take up with the department. And in fact, in one case, I have intend to issue contempt on somebody on the postal department. All are listed on 4th. Please take it up. Whether we can make an arrangement that once notice and the registered post is issued from the High Court, it is mandatory for the postmaster of that relevant post office within 1 month to file a report before the registry. Whether it is served to the person, it is not served to the person, if not, why? So that we can further proceed with the matter. Now, because we are not getting this one, in this one also, neither AD, nothing received, 6 months over of steps, notice being issued. Registry says we have gone for the postal track consignment, something, and pass an order notice is served. But this is only a deemed service.
Whether it is served on the
It is not. Other day, same thing happened in the contempt matter. Contempt matter, somebody now wants to proceed, that will send somebody to jail based on this kind of a. It's getting a little serious. For the entire system, it is getting a little serious. And Postmaster General will depute supervising authorities, either district-wise or zone-wise or whatever it is. If any difficulty, he will take it up. Otherwise, mandatory for every postmaster of that relevant post office, file a compliance report. And if he doesn't, it will be. And if you can think of some other suggestion, you please tell us how to improve it even further.
Somebody today sitting back to
Every matter is going like that. And what will happen, we'll decide it. And after the decision goes, that man will come before the court, said, I never got close this. Recall everything. Please. I thought it is today, but he's informed me that it is on 4th actually. That's why I called you back. What to do? Postal track again. Petitioner to take fresh steps on the respondent to registered post. Respondent to registered post. Inasmuch as acceptance of a deemed acceptance of notice by referring to the postal track consignment is not conclusive that the notice was on fact served.
52.
Hello, this IA has been filed for fixing a date for early hearing, my lord, because the petitioner is retiring in the month of March, my lord.
Mr. N. Sharma and counsel for the applicant states that the petitioner would retire from service in the month of March 2024 and therefore urges upon that the matter be heard prior to his retirement. Mr. has asked and the respondent do not object to such prayer, accordingly list the matter and so forth. It's final consideration.
Next week. The next promotion is set on 1/1/2024.
What did you get?
Hello.
53.
Yes, Mr.
My lord, some urgent situation has arisen, my lord. What has happened, my lord? The petitioners are, my lord, aspirant for their entry into the B.Tech agriculture through lateral mode, my lord. As per
B.Tech agriculture in Assam University.
Agriculture operated
Through
by-
lateral mode, that means?
My lord, the regular mode and there is a lateral mode, my lord, who has passed the Bachelor of Vocational course, my lord. They have been, if just for a moment, my lord, may take to page 43, my lord, of the writ petition, my lord. Page 43, my lord.
Have passed the Bachelor of Vocation from Assam University. University offers the course of B.Tech lateral. Page number?
My lord, page 43, my lord, of the writ petition, my lord. This is the prospectus by which it had been notified. We are concerned with, my lord, undergraduate B.Tech agriculture engineering, duration 4 years.
Page number 43.
43, my lord, 43,
Hmm.
my lord. We are, my lord, aspirant for this course, my lord, undergraduate B.Tech in agricultural engineering, duration 4 years. The second clause, my lord, B.Tech in agricultural engineering, lateral entry.
Hmm.
2 seats will be, my lord, kept earmarked for the sponsored candidate and the maximum age. So
Will
and
be
so and
40
so, my lord.
years, so with 2 years.
My lord.
experience.
So, my lord, the meaning thereby, my lord, those candidate who has passed the Bachelor of Vocation, my lord, from the same university has given this lateral entry mode. My lord. But, my lord, we have passed out, and according to this, my lord, we have applied and we have also been selected. Now the university has said that there is no statutory approval to this mode. Therefore, my lord, we cannot be, my lord, admitted.
Yes, now I is for what purpose?
My lord, my lord, what has happened on the motion day, my lord, our interim was not considered and directed to be filed in affidavit, my lord, but it is more than a month has elapsed and the course is going on, my lord. So if the course is going on, my lord, we cannot, in future, my lord, it will be lapsed, my lord.
Lordship, allow us time to file our application.
Provisionally, if we allow to take.
How much time?
3 weeks, Lordship.
Hmm?
3 weeks.
3 weeks. And what will happen to these candidates? Understand, you could have obtained the instruction much earlier.
5/10/2023.
Notice is not yet issued.
Notice issued, my lord, in
Notice
this case,
issued.
5/10/2023.
So you file it.
My lord, page 59 is also our select list, my lord, wherein we have been selected, my lord. 59. my lord. No, take that.
Where is Mr. Kial?
He's on legs in port number 20.
Ask him to come. Ask him to come.
He's on legs in port hearing matter, Lordship.
So he'll not come today.
He will not be able to come because there are
Please tomorrow.
Well.
Ask him to come with the complete records. Adjourn on the inconvenience of Mr. S. C. Kial and counsel for the Assam respondent Assam University. Mr. A.R. Bhuyal and counsel expresses urgency for an interim order on behalf of the writ petitioner applicants. But when the matter was taken up on 5/10/2023, a submission of Mr. S.C. Kyal, Land Council, Standing Council, was taken note that that there is no statutory provision for lateral entry of B.Voc graduates to B.Tech courses. And there is also, and AICT norms also do not permit the same. The materials based on which the said submission was made be produced before the court. Please tomorrow.
54 for motion.
Yes, Mr. Akon. Oh, I thought you were going to the other side today.
Lord,
Mr. Bhavavati Sharma, Vice Principal, is present before the court. Personal earlier. Personal appearance.
without admit card, he appeared.
No, without admit card. Now what?
I have gone through a judgment of this Honorable Apex Court, 3 judges bench. 2021, volume 7.
It
535. Lord, paragraph.
Page number?
Paragraph 152 to 155.
152.
To 155. It's regarding change of name, correction of name after publication of result by CBS. So, Honorable Apex Court held that there should not be any fetter. And
no, this one I read it in the morning in somebody's matter.
Jigya Yadav case.
No. We relied on paragraph 124. Somebody once name has been changed. Some Ayaton loss to Ayaton Loskor from some other Loskor. And he wants the metric certificate to be corrected. But what is your case matter?
He has submitted all the forms and
I think here is a case for admit card.
Without admit card, he appeared.
Without admit card, he appeared. Admit card not issued because he did not apply for it.
Yes.
Or in fact, the application form depicts wrong information. Not the 5 subjects for this 3rd year, but it is some 2 subjects for some back paper.
So, my lord, I have gone through the documents. It's not technical, my lord, candidate friendly, my lord, that technical aspects, my lord. Regarding ticking of the my lord, papers, he paid entire amount 750. So, my lord, those 5 papers have not been indicated in the form. He indicated he ticked only in a back paper.
Understand.
So, my lord, in the back paper, it will be 450.
So, what is the remedy in this case?
That discussion.
Technically, I know. Technically, you have no remedy. But non-technically, what is the remedy?
My lord, this 150 to 155, my lord, there should not be any fetter, my lord. Since a public body and some discretionary power is also vested to the authority. And this general clauses like section 21.
23. Ask the VC to take a look. That's the only way out, I think.
Section 21.
We passed the same order.
Yeah.
It order 8B or section 23.
Yesterday.
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 Oh, he took it.
Section 20. Item 2, Deepika Das. WPC number 5740, 2023.
That lady who got married in South Salmara now wants to appear from Dispur Law College, that one.
5740. 5740, 2023. Deepika Das Ahmed.
Yes, Mr. Fogan will pass the same order. We'll get that order, do the necessary factual corrections and pass the same order. Okay. Yeah. Wait for some time, please. Yeah.
Five.
Thank you.
In this case, the petitioner also not is challenging the interim order at page 40.
Two. Follow the 5740.
What is this matter, Mr. Saike?
One of this petitioner was initially appointed as LDA. Subsequently, for a person the policy decision of the government, he was upgraded to the post of assistant teacher. Now, my lord, by the imperial order, he has been after serving almost 30 years of service as graduate teacher, my lord. He has been stopped to be reverted back to the post of LDA again. He is only part of retirement, my lord. He is 58 years of age.
Where is the order making him an assistant teacher?
Yes. The scheme is, my lord, page 21.
No, where is that order by which he was
Page
made?
23.
23.
Yes, sir.
This was by the order of the IS.
Mine.
And where is the present order now? Taking it, just seeking to take it away?
Page 11, page 40, my lord, and it's 11.
40?
Page 40, page
40.
have relied on an order, my lord, passed in WBC 5451, which was directed to that which is petition. I have gone to that order. Please paragraph page 41.
WBC 1048, who filed?
My lord.
Sotindranath Teka.
Yes, sir.
Who is he?
The private respondent here in
Private respondent. Was Amal Das a respondent in
Yes,
that matter?
Yes, yes.
Where is that order of the High Court?
Yes, but you will find it at page 32, my.
32.
Against that, my lord, an appeal has been prepared.
Just a minute. Respondent number 4.
Yes, please.
Amal Das is 4 there.
Yes.
What are these matters? Sadananda Boisya, Gautam Boisya,
My lord,
Lux.
Sadananda Boisya, he was also in LDA, my lord. He was upgraded against even a suspension vacancy. There was no post. The person who was suspended, he was
In
reinstated
those
in
days, the
service.
issue just. Where is the circular dated 28/6/1993 allowing upgradation?
Page 21.
Page
21.
Was it placed before district levels selection board? Your case after upgradation?
Yes, ma'am.
It was placed
After that, my service has been confirmed also.
by the DLC. Heard Mr. I, Psychiatric and Council. You also want to say something?
Well, the district level selection board, my lord, there is no material in the repetition to show that it was placed before the election.
At least
In fact-
he has made a submission.
In fact, page 23, the upgradation order also does not mention about the district level.
No, it need not. It is to be subsequently placed.
My lord. And if your lordship will find the speaking order, my lord, here, my lord, the following the judgment of this honorable court in these two repetitions, my lord, where it has been treated that there cannot be any upgradation. In fact, the earlier round of litigation at para 14, my lord, will kindly find it.
We have read
Where
it.
in the repetition that
No,
is filed by Jotindranath Dekha,
We have read it.
my lord. This honorable court has categorically observed, my lord, that there cannot be any upgradation from to the post of assistant teacher.
But he relies on page 21, which was in force at that
Page
relevant
21,
point of time.
I'll have to take it.
So
Whether-
this observation will be per inquirium of this one.
Right.
So now when he is relying on this one, we have to examine his claim from this point of view.
Page 21, my lord, I'll have to take it.
All the earlier judgments,
Whether there was any.
Sadananda
policy
and all is not in respect of this petitioner.
It is not in.
Number one. Only thing
the
in
ratio
this
that-
respect is that para 14,
My lord,
the rules did not provide for this thing.
my lord.
But this is per inquirium of the communication at page 21.
Page 21.
So
Page-
we'll have to look into it.
Yes.
Otherwise, a man who worked as teacher for 30 years, number one, you allowed him to do B.Ed. You allowed him to go for master's degree. He has all the qualifications. Moreover, he had taught students for 30 years. In one stroke of pen, how can you take it away, everything?
No.
If he was not entitled, then the next question is, why did you allow him to be so? Who asked the inspector to allow him?
In fact,
And so, timing, let us hear the other side.
apart the by the same upgradation order, the another man was also, and the speaking order has also reverted his service to.
No. Plus, you cannot revert it. Plus, the order of the High Court is to determine the issues. That is, who is senior.
Yeah.
High Court never said, pursuant to this order, that you also revert him.
But that illegality, my lord, has been detected by the authority.
No,
But
so-
while
so no-
determining the seniority.
Understand? So you have to follow complete procedure.
Fine.
All thing we are saying, it can't be decided in one stroke of pen.
Fine.
Heard Mr. Ayat Cycle and counsel for the petitioner also. Notice 6 weeks, extra copies 3 days. There is a dispute of seniority between Jyotindranath Deka, the respondent number. Saikya, which one? 4. And the writ petitioner, Amal Kumar Das, as to who is senior as teacher in the name of the school,
Korea High Secondary.
Korea High School,
Higher
Higher Secondary School. Full stop. There is it. This would resulting in WPC 1048/2019, which was given a final consideration by the order dated 22/2/2023. In the order dated 22/2/2023, a submission on behalf of Jyotindranath Deka was taken note that Amal Kumar Das was originally a LD assistant in the school con, but later on was updated as an assistant teacher in the school. Full stop. Accordingly, certain judgments of this court rendered in the order dated 2/12/2014 in WPC 5451/2012, page 35 with us, were relied upon, wherein a proposition is said to have been laid down that there is no provision under the rules to upgrade LD assistant to that of to an assistant teacher. In para 14 of the judgment, the court also took note that the rules of 1982 also did not provide for any such provision for promotion or upgradation of an LDA to the post of assistant teacher. Accordingly, the matter was remanded back to the director for a determination of the inter-seniority between Jyotindranath Deka and Amal Kumar Das. The said determination was made by the order impugned dated 9/10/2023, wherein the factual aspect was taken note that Jyotindra Kumar Nath Deka was appointed as an assistant teacher as per an order dated 22/5/1998 with effect from 1/4/1997 in a circumstance where earlier he was a Hindi teacher. Equal. Not that so and so. In the order, it was also taken note that the Amal Kumar Das was initially an LDA and thereafter upgraded, promoted as an assistant teacher. Accordingly, by referring to the judgment rendered in the aforesaid writ petitions, that is Sadananda Boisyo Supra and others, a conclusion was arrived that in view of the judgment rendered in Sadananda Boisyo, an upgradation from the post of LDA to that of assistant teacher was not done in conformity to the government rules and procedures in force, and therefore a decision was taken to revert back the petitioner Amal Kumar Das back to his post of LDA. The said order dated so and so is a said in district petition. We have taken note that in Sadananda Boisyo Supra, according to the Director of Elementary Education Assam, an upgradation from the post of LDA to assistant teacher cannot be done without conforming to the government rules and procedures in force. Mr. Ayed Saikia, Learned Counsel for the petitioner, refers to a communication dated 28/6/1993 of the Director of Elementary Secondary Education Assam, secondary made to all the inspectors of school that providing that a grade 3 or a grade 4 employee having requisite qualification for assistant teacher may be appointed on ad hoc basis without selection, but subsequently their candidature should be placed before the district level selection board for selection and regularization as assistant teacher. As the communication dated 28/6/1993 did exist and was in force when the petitioner Amal Kumar Das was upgraded as assistant teacher, it cannot be prima facie said that the upgradation was done without conforming to the government rules and procedures in force at that relevant point of time. From such point of view, it appears that there is a factual variation from that of the proposition laid down in Sadananda Boisyo Supra. In view of the above, the state authorities are required to produce the complete records, more particularly in relation to the communication dated 28/6/1993. Secondly, as required in the state communication, information be also provided as to whether the promotion of the petitioner as assistant teacher was placed before the concerned district level selection board. In this respect, we take note of the statement of Mr. Rai Sakia, petitioner, that the petitioner Amal Kumar Das, that the upgradation of Amal Kumar Das as assistant teacher was also placed before the district level selection board, and the board had approved such upgradation. In view of the prima facie case being made out, the reversion of the petitioner Amal Kumar Das as a LDA stands state, shall remain state until further orders. Reversion is state.
The order that is 22/2/2023 is an interim order, not final decision.
Which one?
The earlier petition filed by tribunal.
What happened to that petition? It is stated that the order dated 22/2/2023 in WBC so-and-so is also an interim order, and the writ petition is pending, list along with WBC so-and-so.
But that communication is by the joint director.
Sorry.
The communication of 28/6.
Joint director, by the joint director.
And my lord, in that order which I relied, my lord, para 14 and 25 to 32, my lord, the honorable court has
No.
decided that. Para 14 as well as from
Firstly, it's an
25 to
interim,
32.
firstly, it's an interim order.
Yes, yes.
Secondly, it's per inquirium of that one.
Yes, yes.
Because that was not produced before the court by either of the parties.
Right.
So court thought
Right.
the rules does not provide, it is not there.
Right.
But the director says, conforming to government norms prevailing. If norm is prevailing, it is a different aspect. We'll examine it.
Well,
56.
But reversion of a man who everybody knows to be a teacher for 30 years,
my lord.
suddenly you make him a clerk.
Why do you
It's a little.
In fact, my lord, the last paragraph of that earlier order, that was perhaps be taken by note by the authorities, madam, where this honorable court says that if these procedures are not followed, then these orders are void ab initio.
No, everything
Yes,
is not. It is void ab initio if it is
But
fraudulent.
that of course,
But your inspector is giving him.
madam.
You made him work. You
When
made him acquire the B.Ed degree. You made him acquire the M.A. degree. He's supposed to be a good teacher in the school, no complaint. And after 30 years, suddenly everything becomes void ab initio. Oh.
Para 32 of this honorable
There has
court
to be a equitable balance
when the
also.
authorities get observation from this honorable court that para 32 as in this manner, my lord, they don't see other things.
That equitable balance has to be there. Now, everything is not so technical.
We'll respond, my lord.
Please. 57. It was. बस तो काली कोराई हल देंगी एक पड़ेगा और it be hearing to कल एक पड़ेगा yes Mr. Abedin.
May I please, Your Lordship? My lord, the district scrutiny committee, my lord, recommended 4 teachers, including me. Over there, my lord, 2 language teachers were there.
Petitioner is what, language or?
Language. Ultimately, the provincialization was made in respect of 3, 2 language and 1 science and maths. So that social studies person was left out. He approached this honorable court. And my lord, first there was a notice of motion on 5/7/2021. And then on 7/3/2022, that is March 22, the petitioner withdrew his writ petition with a liberty to file again. Then in the month of May 2022, he approached, and this honorable court was pleased to issue notice of motion as well as benefit of mine, because among the 2 language teacher, I was the junior. So my benefit was stayed. My benefit was given not to give an effect to. What happened, my lord? The writ petition which was withdrawn, which was dismissed on withdrawal in the month of March 2022, a hearing was conducted in reference to that writ petition after 12 months, this is 2023 5. And incidentally, my lord, on 1/11/2023.
Where is that order? That after 11 months, that order?
My lord, the order, withdrawal order, my lord, page.
No, withdrawal, we've seen that order after 11 months.
My lord, order that page 40.
Page 40.
Yes, my lord, 40 and Lecture 8. My lord, it is there in the subject itself. In connection with writ petition 3202. That is, your lordship may see the date 24/5/2029. And that case already stood withdrawn on 7/3/2022.
So now what do you do? Set aside this one.
No, my lord. Next. Now my provincialization cancelled on the basis of that hearing, my lord. And I'm going to retire tomorrow, my lord. So let the order be stayed so I can retire happily. The other person will automatically from day after tomorrow will come.
My lord, perhaps with this order may be passed on the basis of the order, my lord, page number 38, my lord. Here, my lord, they have written the WP number long.
Had you done it immediately, we would not have nothing to say. But once the writ petition withdrawn, this order ceases to have its effect. And after the order ceases to have its effect, you cannot implement the order and pass an order.
This order has been passed on the basis of the order, my lord, passed in WPC number 3259, my lord. 2022, my lord, not that WPC number, my lord, which petitioner has
In
already
compliance of the order dated 6/5/2022. Where is that order?
My lord,
Page number 38, my lord.
38.
my lord, that order is page 38 it starts. 38 it starts. My
Start.
lord.
And this is writ petition?
This is a repetition, my lord.
2359.
Yes, my lord.
2359. Now, where is the order dated 6/5/2022 in WBC 2302?
My lord, earlier one, my lord, page.
My lord, 2302 is relating to, my lord, some other matter.
3202 is there. There is no 2302.
It's 3202, my lord.
3202.
Yes, page 35.
What does it say?
Page 35, page 36 is the order.
7-3, withdraw the petition. 3203 is withdrawn.
Yes.
Where is the order dated 6/5/22 in 3202?
320.
Where is that order?
2302 is, my lord, some other matter.
That's the my lord's order, my lord, 2359, Annex 7.
It is order dated 6/5/2022 in 2302, not 2309, and not 2359.
My lord, my only these two cases are there. There, I think this is some type of graphical error.
I understand. First, you have to bring in everything on record. Then only we'll pass the order in a favor. We are ready to stay it, but our recording of the order has to be right. On the legal principle that an interim direction of the court cannot be given effect after the writ petition had been withdrawn. We are agreeing with that principle. But to make the order correct, the case number should also be right. List on Friday for verification of the writ petition numbers involved in the order dated 6/5/2022.
Could it be tomorrow? Tomorrow he's retiring. So at least.
Tomorrow he's retiring.
Yes, yes. Otherwise, this cancellation order will stand.
Let a man happily retire.
In fact, if I can clarify, Manoj, the order that has been recorded as WPC number 2302/2020, we have checked, Manoj. That's some other repetition, not related to this.
So
perhaps, Manoj, the 6/5/2022 order is page 37.
37, it appears.
The repetition number is wrongly been recorded.
But that repetition is does not exist.
No, this repetition exists.
Which one?
2359.
2359 consumption pending in disposal.
No, it's pending. They have given the order. That is more serious. My lord did not give any issue to give them the hearing. They are saying.
By the Imperial Service Board.
They are saying in compliance
Just a minute.
with my lord's order. I didn't bring on to
2021.
2022. Pending.
Who is the petitioner in that case? Orup. And who is the petitioner here? O'Neill.
Yes, that's one number 6.
Third, Mr. G. Abedin, Land Council Petition, MSS, Studio for the Elementary Education Department. Any more respondents?
No. Private. Only private respondent or finance.
Notice 6 weeks, extra copies 3 days. Steps on respondent numbers. Finance, Mr. B. Gogoi for finance. Steps on respondent or registered post 3 days. An order dated 1/11/2023 of the Director of Elementary Education Assam is assailed in this petition, which is extracted as below. A reading of the order makes it discernible that the said order was passed in compliance of an order dated 6/5/2022 in WBC 2302/2021, whereby the provincialization of the writ petitioner was cancelled. We have perused that. The order dated 6/5/2022 in respect of the in respect of a writ petition by Arup Kumar Saha versus State of Assam is in fact WBC 2359/2022, which writ petition as per the information provided is still pending. Further, in the order dated 6/5/2022 in WBC 2359/2022, there is no such order requiring the Director of Elementary Education Assam to cancel the provincialization of the writ petitioner Anil Kumar Roy. In view of the above, the order dated 1/11/2023 cancelling the provincialization of the petitioner shall remain stayed until further orders, meaning with a clarification that the petitioner would deem to be in service as a provincialized employee.
The concerned person is not a party, made party.
There is no private party, so no registration, registered post required.
No reason.
My lord,
You retire happily, ask the man.
can we take it with that pending case?
Why you create your own problem?
No, that
Why do you,
my lord, we will welcome him to the post.
why do you create your own problem?
57.
Deeply obliged, my lord.
You got your benefit, be happy. After some days, say it is infractious, enjoy your pension.
No, nothing, no pension, nothing, my lord.
These are no
No,
pension.
nothing. Only this remaining salary I'll get. my lord.
Okay. Yes, Mr. Yar Bhuiya.
My lord, hearing, my lord, we have challenged the selection process, my lord, regarding, my lord, assistant professor in the Department of Agriculture, my lord, in the Assam University Silchar. My lord, the ground of challenge is that the roster has not been maintained, as well as, my lord, the selection committee, which are required to be in accordance with the guideline of UGC, has also not been constituted, my lord.
Have you given copy to Mr. Kia?
Yes, yes, my lord, we have
easy.
communicated, my lord.
One young girl came and said that no, he is in
My lord, then the last.
legs in some hearing matter and he'll not be available for today.
My lord.
I think somebody made that
Yes, yes, my
statement.
lord, his colleague, my lord, informed my lordship, my lord.
Mm. What to do? You are also there. Mr. KL will not be available today.
Lordship, my senior is another board.
I know. Today he'll not be available.
My lord, in his absence, tomorrow, if my lord allows, my lord. Tonight. My lord.
It's stated that Mr. S.C. Kal and council is having some inconvenience today. Adjourned to be listed again tomorrow.
My lord.
কোন কি এটা এই বইটা পাবি গাড়ি কামাটা বই
58 for admission.
What did you get? Even I had thought about this matter, even after.
No, my lord, Lord kindly turn to page 71. They've explained it to me. My lord, I have to something to publish.
No, explanations are there, but logically, one aspect we are unable to accept. Before revision of pay for this particular category of employees, okay, the pay scale starts at 12,590. 5590. Okay. So total comes to 1790 or something. What was that?
17,900.
17,900. So this is the starting scale.
Yes, that is the wrong implication of the petitioner so far as the fitment regulation.
No, no.
I can explain it to you.
No, no, you'll explain. That is the,
There is no applicable.
understand, that is the minimum scale before revision. Okay. But this category of employees, for them, you are also required to add the PSP to the basic. So whosoever is in the minimum scale, to his basic, PSP will be added. So minimum for that man will be now 19,150. So there cannot be any employee of this category who can ever have a scale of pay less than 19,150. Meaning thereby, the minimum scale of pay, expression minimum scale of pay for these employees will be 19,150. Because it is not possible for you to give them anything less. The floor is 17,900. Normal for any other kind of employee, it will be 17,900.
That is not the procedure for calculating the for fixation of a
No,
individual who has been
don't
promoted.
get time being, don't get clogged with the fixation and all. Huh? Floor is 17,900. Any employee of that category ordinarily would have been 17,900. But for the category of employee of this nature, it cannot be 17,900 because you will have to add 12,500. So he becomes 19,150. So for this category of employee, floor is 19,150. There cannot be any minimum scale beyond 19,150. Okay.
No, that's not that is version.
Not version. Then what is the correct?
May I Worship will have to, my lord, may kindly have a look at 11 again.
No. 11 will go a little later. First,
Then Lordship will make
only
one thing, my lord.
let us understand there is no revision. Suppose let us understand there is no revision.
May I submit in that regard, my lord? So far as the petitioner is concerned, while he was working as grade 2 personal secretary, he was under payment 3. After promotion in January 2017, he came under payment 4. So now the minimum pay scale for that, my lord, basic pay has been already fixed for payment 4. Lordship will find it in a table number 1 of that particular compilation.
This one, ROP.
Yes, it will be page number 286. What you will see, my lord, here serial number 4 at the top, existing pay bill. In the promotion order of January 2017, the pay therein is, my lord, 12,000 is card. Now, Lordship will see, my lord, in that particular pay bill, the revise will be, my lord, 30,000, 1,10,000. That is it has been fixed in the ROP. Since the petitioner was promoted in January, now while calculating, my lord, this will have to be taken. Not that, my lord, what they are trying to project that, my lord, 12,000 plus 5,900 plus 1250. Taking that, my lord, we will have to go to the fitment. Here, that's not the case. In case of promotion, in case of this particular employee or the petitioner, since he has been promoted, the base, my lord, the minimum pay in that particular payment has been fixed as 30,000, 11,000. That is not by calculating from the fitment table, as has been placed by the petitioner. This is his version, his understanding. Now, Lordship will see, my lord, why I am saying this. Lordship may kindly turn to page 306. My lord, payment is, there's a definition in relation to any post or grade is specified in column 2 and 5 of the
Just
table 1 of chapter
306.
Yes.
306, yes.
Yes, Lordship will see the definition payment.
Hmm.
It says, my lord, payment in relation to any post or grade is specified in column 2 and 5 of the table 1 of chapter 1. Chapter 1 table is at 286. And chapter 1, Lordship will find, my lord, the before the, my lord, gazette notification. Now, my lord, coming to, my lord, rule 11. At the same time, Lordship may also, my lord, take out this page 71. Rule 11A.
Page number, rule 11.
It's, my lord, 311. Relevant will be 312. 11A. It says one increment equal to 3% of the sum of existing pre-promotional pay. Lordship may kindly mark this pre-promotional pay. So while refixing, my lord, his scale in the promotional post, it will have to take, my lord, his pre-promotional pay. That lordship will find.
What is the pre-promotional pay?
Yes, that's why.
No, according to that's the figure. What is the pre-promotional
The
pay?
pay that he was receiving on the day prior to the promotion. That's why, my lord, in the calculation, the date has been given. There in this particular, my lord, calculation given in page 7.
So no, what pay he was receiving prior to the day of promotion?
Yes. My lord, since he was
No,
grade-
just a
that's why
minute.
I'm
Please give the
since he was
figure.
Grade 2.
Mr.
It
Gogol,
has
please,
been revised and revised is, my lord,
no, please give the figure what he was receiving on the day prior to promotion.
38640. That is
38640. He was not receiving. He was not receiving.
It says the last
No,
pay drawn.
no. He was not receiving because on the day he was promoted, there was no revision of pay.
No.
He-
Yeah.
This is what we were pointing out yesterday.
No.
Just Mr. Gogoi,
He,
Mr. Gogoi, please understand the issue. The pay he was receiving on the day prior to his promotion actually is the pay he was receiving before the revision. That is some.
it will have, it has a
No.
effect. It will have to be revised first.
No,
Grade 2 post. it will have to be revised
Mr.
first.
Gogoi, this is where you are faltering. You are trying to, just a minute. You are now revising the pay of this man in two stages. First, you will revise the pay, just a minute. First, you will revise the pay in his original posting grade 2. Okay. Arrive at all your calculations. Then second phase, you revise his grade 1.
Fixation. Yeah.
To do that, as you have already revised it in the grade 2, therefore you are arriving at the revised pay for revised pay as regards the pay he was getting prior to his promotion. But rules nowhere enables you to revise in two different stages. You have to revise it in one go.
Yeah.
When you revise it in one go, the revised pay he was receiving before promotion, his figure is not available to you.
It's there, my lord.
It's not there.
It's there, my lord. Page 71, lordship may kindly have a look at.
It is not there. You have wrongly taken it into account. This is what we are trying to point out from since yesterday.
Lower post, my lord, lordship will see the heading. As per rule 11 of the Assam Provincial Red with Provincial. 1. Lower post. Stenographer grade 2. Page
Which
structure
page you are referring?
71 is the part of our affidavit of opposition.
71 is some paragraph of the affidavit. Must be something wrong with you, President.
Annexure A, not annexure.
78. This is 78, not 71.
Running page number, my lord, 78.
No, it's running page
My,
78.
it's a letter dated, my lord, 11th of
11 June, very well.
Lordship will see. After the payment, my lord, accordingly, the fixation has been done in respect of Hasnin Alok, stenographer grade 1, principal is in the following manner. As per rule, so here lower post, stenographer grade 2, pay structure of the post is 22,970. Date of release is 23/1/2017. Now last pay draw, one that is 23/1/17 is 38640. Here, my lord, PBP pay in the pay ban 28240 plus grade pay 9400 plus 1000. So this, and here lordship will find, my lord, in the pay structure it is only 22,000. Here it has been taken as 28240 because of increment he was receiving higher. So this has been considered. Now lordship will see the higher post. I have shown the, my lord, place the, my lord, table number 1. Lordship will see pay structure of the post. Pay ban 4, it is 30,000 to 1,10,000. with grade pay of 13,300. Date of joining is 23/1/17. That is the date when he was promoted. Now fixation. For that, Lordship will have to, my lord, may I place, my lord, this rule 11A, B, and C again. Ma'am. Then I will go to this chart in column 3, in para 3. It says, my lord, one increment equal to 3% of the sum of the existing pre-promotional pay in the pay band and the grade pay corresponding to the pre-promotional post shall be computed and rounded off to the next multiplier of ₹10. Here, Lordship will see 1, Roman 1. Last paid row is, my lord, 38640 as in, my lord, in para 1. Next, my lord, one increment 3% of 36410. It's 1160. Total is 3980. Now, my lord, there's certain subtraction, my lord, some amount has been deducted. For that, we'll have to see, my lord, B. In case of promotion, revised pay of pay band shall be fixed by adding the amount arrived at clause A above to the existing pre-promotion pay of the employee in a pay band. Now, in order to take out the pay band, my lord, minimum pay band, we'll have to deduct the grade pay as well as the PSP. So, my lord, number 6, pay in the pay band 3 is 29,400. There, my lord, Lordship will see in the, here now C, my lord, in case the promotion from one post to another involves movement from one pay band to a higher pay band, then also fixation of pay consequent to promotion shall be done in the same manner as A and B. Or, my lord, in B, the last line, he will also be given grade pay the enhanced rate as applicable to the promotional post. In the promotional post, the grade pay is 13,300 in para 2. So it has been added. Now the PSP 1250, it has been added. The figure comes, my lord, 43950. Now, my lord, taking the proviso of, my lord, sub-rule C, it has been rounded up by increasing it to 44550 by again adding, my lord, 1250. So this is the figure, my lord. As per rule 11, this has been calculated. This ours 10, my lord.
Okay. Yes, Mr. Das, you want to say something?
The way the finance has given us instruction. And
no, do you want to say something on him or you are simply following it?
Sorry.
You want to make some more submission or you are simply following what finance has done?
No, what finance is done, we have followed that and we have done the fixation according to that. One thing I'd like to, my lord, for your lordship's, my lord, convenience, I think, my lord, lordship will point me if I am wrong, my lord. Lordship will still having that 17,900 thing in your lordship's mind, my lord, when he's in the pre-revised, my lord, post, that last page of the petition, 17,900 grade pay, then PSP 19,150. Look, that 17,900 thing, after if the pay is revised from 1/4/2016, those 17,900 grade pay or 19,150, those things, my lord, disappear. So perhaps, my lord, to understand this chart and the fixation, subject to correction, my lord, lordships have to, my lord, just keep that thing away from your lordship's mind to appreciate this chart. If that 17,000...
We are not keeping anything away.
No, my lord, what
no court can look into something, keeping something away. We have to take note of everything and then look into it.
Lordship will keep it in mind, but while appreciating this chart, because
no, this chart minus the what you are asking to keeping away is right. Only thing is when you bring it in, it is having some inconsistency.
That 19,150, once revision is done from 1/4/2016, that 19,150 is done away with.
Very well. Understand.
That 19,000.
Understand what you are saying.
No longer
Mr.
there.
Das, you don't have to repeat. We understand.
Fine, madam.
And once you say it is good enough for us to understand. If I don't understand, I'll ask you.
Yes.
So please repeat it.
Yes.
I have not asked you, miss. I understand.
Fine, madam. So,
secondly, the repetition will also not make it
No, that thing I have in my mind.
Okay,
So
sir.
I would
Yes,
like
what do you
expressing
say?
your lordship.
My lord, my one submission is that the gazette notification came in March 17, 2017. On that particular day, I am a grade 1 employee of this honorable court. So my basic was 19,000. My basic was 12,000 plus my 5,900 plus PSP is my basic stands to 19,150. Problem came in because it has given retrospective effect. At this stage, even I'm ready to forego my grade to this thing. Then if retrospective effect wouldn't have been there, then as on date, I would have been got the pay of, it has to come in the fitment table of 19,150, which the respondent, they were saying that they have done the.
Okay, anything more?
No, lordship. And
Both of you will be ready to go in appeal. Heard MSD Ghosh, Land Counsel for the petitioner. Also heard Mr. H. Das, Land Counsel for the respondents in the Guwahati High Court, as well as Mr. B. Gogoi for the respondents in the Finance Department of the Government of Assam. The writ petitioner, Hasnain Alam, was appointed as a, what is the appointment order? Initial was
initial.
page number.
March, grade 2, page 20, lordship.
Was appointed as stenographer grade 2 in the principal seat of the Guwahati High Court in the pay band of rupees 8,000-35000 bracket PB3 with grade pay of 4,300 plus other allowances as admissible under the rules. Later on, the petitioner was promoted as, where is the promotion order?
Promotion order is that page, lordship. Page 35, lordship.
Was promoted as private secretary in the principal seat of the Guwahati High Court in the pay band of rupees 1,2 in the pay band 4 pay band to agote diba PB3 or PB4 of rupees 12,000-4,000 plus grade pay of rupees 5,900. Without there being any other entitlement and without there being any revision of pay, the petitioner was entitled to the basic pay as stenographer grade 3 of PB3 of rupees 8,000 plus grade pay of 4,300 subject to increments from time to time as may be applicable. Mr. Das and Gogoi, please listen carefully. If I'm going wrong, please point out somewhere. Because factually, we should not be wrong.
My lord.
Interpretation, meaning judgment, that is our prerogative. So and so. Similarly, without there being any revision of pay and without any further entitlement, the petitioner, upon being promoted as private secretary in the pay band in PB4 1200-400 plus grade pay of 5,900 would be entitled to the basic pay of rupees 12,000 plus grade plus rupees 5,900, which is equal to rupees 17,900. But the petitioner, being an employee of the permanent seat of the Guwahati High Court, is also entitled to special pay, entitled to a pay, nomenclatured as principal seat pay. Which had been notified as per the notification dated 16/8/2016 of the legal remembrancer and secretary to the government of Assam in the judicial department. The notification dated 16/6/2016 provides the principal seat pay to bracket PSP code. The PSP to be rupees 1,000 per month in respect of those employees of the permanent seat of the Guwahati High Court who are in the pay band 3, and rupees 1,250 per month in respect of such employees who are in PB4. In other words, the present petitioner, while he was serving as stenographer grade 2 in a scale of pay in the pay band of rupees 800 plus grade pay of rupees 4,300. His basic pay, the comma, rupees 1,000 would have to be added to his basic pay as PSP, full stop. Meaning thereby his total basic pay would be 13,300 per month. Of course, subject to further periodic increments as may have prevailed. I got a notification quote kori thoi dibo, quote dibo. Paragraph 1 of the notification provides. Paragraph 2 of the notification dated 16/6/2016 provides that the PSP shall be, in addition to their respective pay in the pay band and grade pay, and accordingly a formula is provided in the notification itself as to in what manner the basic pay is to be calculated upon taking note of the PSP, which is basic pay is equal to pay in the pay band plus grade pay plus PSP. The aforesaid calculation that we arrived at is precisely based upon the said formula that the basic pay of the petitioner in stenographer grade 2 would be pay in the pay band, that is rupees 8,000, grade pay, that is rupees 4,300, plus PSP of 1,000, which would be 8,000 plus 4,300 plus 1,000, which is equal to 13,300. Upon being promoted as private secretary by the notification dated 23/1/2017, the pay of the petitioner had been fixed in the pay band 4 of rupees 12,000-40,000 plus grade pay of 5,900. Accordingly, immediately on being promoted, the petitioner would be entitled to a basic pay of rupees basic pay comprising of PB4, that is 12,000 plus grade pay of 59000 plus PSP of 1500, and by adopting the formula provided in the notification dated 16/6/2016, his basic pay would be 12000 plus 59000 plus 1250, which is equal to 19150. In other words, we have to understand that under no circumstance the minimum basic pay of the petitioner could have been less than 19150. As per the ROP rules 2017, which was implemented on and from 17/3/2017 with effect from 1/1/2016, there is a revision of pay in respect of, there is a revision of pay. Where is that calculation for that grade 2?
Grade 2, page 37. Lord.
37.
Yes, Lord.
But the effective date is 1/4/2016, not 1/1.
1/4, sorry, 1/4. To give effect to the revision, the basic pay of the petitioner, as per the fixation of initial pay available as Annexure 7, page 37 to the writ petition. In clause 7, the basic pay of the petitioner in the pre-revised structure was accepted to be rupees 14,550, which is 9,250 being the payment, plus rupees 4,300 being the grade pay and 1,000 being the PSP. In other words, the basic pay was accepted by the authorities to comprise of 3 elements, that is the pay band, the grade pay plus the PSP, and the cumulative effect of the same was considered to be the basic pay. Accordingly, the fitment of the petitioner after revision was on the basis of a basic pay being rupees 14500, which also included the PSP, and accordingly the revised pay was arrived, which also included pay band, grade pay plus PSP, was arrived at rupees 37,1600. What we have specifically taken note of that, in order to arrive at the revised basic pay, the existing basic pay included 3 components, that is PB, grade pay, and the PSP. The further issue remains as to what would be the revision of the pay of the petitioner in his promoted post of private secretary. For the purpose the finance department of the government of Assam has issued a communication dated 11/6/2021, for fixation of the revised pay of the petitioner as private secretary, which is also referred as stenographer grade 1. Extracted below colony, which is extracted as below. A reading of the communication dated 11/6/2021 makes it discernible that calculations were made in respect of how the pay of the petitioner was revised as a stenographer grade 3, grade 2, and also how it stood revised as stenographer grade 1. While calculating the revision of pay as stenographer grade 1, the ultimate figure that was arrived at by the authorities is rupees 43950. 43950. But it was found that the figure 43950 was less than the minimum pay in the pay band 30,000-1,10,000, which with grade P of 13,3000 and PSP of 1250, which came out to be rupees 44,500. Accordingly, clause 11 of the Assam Services Revision of Pay Rules 2017 was invoked. Full stop. Rule 11 of the rules of the ROP rules so and so is extracted as below. Mr. B. Gogoi, Learned Counsel for the Finance Department, by relying upon the provision of Rule 11(1)(a), submits that in order that as the petitioner is a category of employee who was promoted after 1/4/2016, his pay, his fixation of pay in the higher post where he is promoted would be one increment equal to 3% of the sum of the existing pre-promotion pay, and accordingly seeks to justify the calculation made in the communication dated 11/6/2021 that the existing pre-promotion pay of the petitioner was rupees 38,640, and therefore 3% was added to it, and accordingly the calculation made out in the communication dated 11/6/2021 was carried forward. Reliance is further placed on the proviso, which begins with the expression however of Rule 11, which provides that if the revised pay arrived at by following the calculation provided in Rule 11(1)(a) becomes lower than the minimum of the higher pay band to which the person has been promoted, then the pay shall be fixed at the minimum of the higher pay band. Accordingly, by referring to page 206, some 280, by referring to table 1. What is table? Table 1 of the pay structure provided in the notification number FPC stop 1 stop 2017 stop PT hyphen PT hyphen 1 dated 17/3/2017. It is stated that the writ petitioner having been in the existing pay band of rupees 12,000 hyphen 40,000 would be in the revised pay band of rupees 3,000 at 30,000 hyphen 11,000. Coming to it, don't worry. 00. It is noticed that the ROP rules had been notified as per the notification number FPC stop 1 stop 2017 stroke PT stroke 2 dated 17/3/2017, whereas the notification containing the pay structure is as per notification number FPC stop 1 stroke 2017 stroke PT stroke 1. Which apparently appears to be two separate notifications. And be that as it may, by referring to the figures 30,000 hyphen 11,000 as appearing to be the revised pay band as per table 1 referred above, it is the submission of Mr. B. Gogoi and Counsel for the Finance Department that the minimum of the higher pay band referred in the proviso to Rule 11(1) of the rules of 2017 would now have to be read to be rupees 30,000. I think this is a submission. Accordingly, the calculations available in the notification dated 11/6/2021 is thought to be justified. Inasmuch as it also provided that the pay of the petitioner had been fixed at rupees 44,500, which is stated to be PB4 of rupees 3,0000, grade pay of rupees 13,000 plus PSP of 1,250. In other words, we are required to examine as to what will be the meaning of the expression, one inverted comma, minimum of the higher pay band as appearing in the proviso to Rule 111. For any other employees under the government of Assam, the meaning of the expression minimum of the higher pay band would have to be understood to be as what is submitted by Mr. B. Gogoi, Land Council of Finance Department, that it would be PB4 of rupees 30,000. But the present petitioner, being an employee of the permanent principal seat of the Guwahati High Court, whether the same meaning given to the expression minimum of the higher pay band would also be applicable requires an examination. If we examine the fitment table which is available at page 40 annexure 9 to the writ petition, which is table number 1.22 of the ROP rules 2017. It's a table of the ROP rules.
Yes, sir.
Of the ROP rules 2017, comma, the revised pay band is provided in the manner that in respect of ROP rules 2010 of PB 12000-40000 with grade pay of 5900, the total being rupees 17900. The revised PB would be rupees 30,000-1100000, where the total pay is shown to be rupees 43,000, of which the PB pay would be rupees 3,000. But we have already analyzed that in respect of an employee of the principal seat of the Guwahati High Court, in the pre-revised pay structure, the basic pay, which otherwise comprises of PB plus the grade pay, PB and GP, PB and GP, and which otherwise would have been rupees 17900, would be inapplicable in respect of an employee of the principal seat of the High Court, inasmuch as by following the formula provided in the notification dated
16th August
16/8/2016, the basic pay would be PB plus GP plus PSP. So when we add the PSP, the basic cannot be 179. Basic cannot be 17900. When the basic pay in the pre-revised structure cannot be 17900, and it would be, and the minimum basic would be cannot be and it would be, and the minimum basic would be 19150 by adding the PSP, comma, the applicability of the minimum basic pay upon revision cannot be the fitment equivalent of 17900, whereas it has to be equivalent to the fitment of rupees 19150, which would be as per serial number 4 of the table 1.22, that is 19570. Of which the corresponding total pay is rupees 47320 and PB of rupees 34020. In other words, when the pre-revised structure had taken away the minimum basic pay of the employees of the principal seat, and the minimum is at rupees 19150, the equivalent of the minimum through the fitment by going to the by referring to the minimum possible would also be not applicable in respect of an employee of the principal seat of the Guwahati High Court. Upon revision, the equivalent fitment of a minimum of the higher pay band in respect of an employee of the principal seat of the Guwahati High Court would be corresponding to the fitment against serial number 4, where the total basic pay before revision was 19570, which after revision would be 47320, of which the PB would be rupees 34020. As the minimum of the basic pay before revision and after revision, as provided in table 1 referred above, as well as table 1.22 referred above, are not applicable to the employees of the permanent seat of the Guwahati High Court, the expression minimum of the higher pay band in the proviso to rule 1.1 of the ROP rules of 27 would also have to be read as such. Accordingly, the minimum of the higher pay band upon revision of the present petitioner would have to be accepted to be the pay band which would be corresponding to serial number 4 of the table number 1.22. If the minimum of the higher pay band upon revision and on promotion and after revision, as well as prior to revision, is not applicable to a particular category of employees, the same minimum of the higher pay band after revision cannot be made applicable to that particular category employees when the fixation of pay is made to the higher post after the revision of the pay. With the aforesaid observation, the respondents in the finance department is directed to work out the communication dated 11/6/2021 as regards fixation of the pay of the petitioner in his higher post of stenographer grade 1 after applying the revision under the rules of 2017. We are specifically interfering with the provision in the penultimate paragraph of the communication dated 11/6/2021 that the minimum of the higher pay band of the petitioner is taken to be rupees 30000 by leaving the other calculations intact as it has been provided. Go, Mr. Go, appeal.
11B.
11B is by adding the
Divide in the pre-promotional pay.
this we are not observing because we are not interfering with that part. That part we are accepting.
I relied upon.
Although in deliberation, I referred existing.
No, I relied upon my lord A, B, and C of it to 11.
Huh.
That my submission is that my lord, while calculating my lord or refixing the my lord pay of a person who has been promoted after 1,000.
No,
Rule 11 A, A, B, and
we are accepting the submission of Mr. Bigwell that in respect of calculating the revision of pay of a person who had been promoted after 1/4/2016, the provisions of Rule 11(1) A 11 bracket A, bracket B, bracket C would be applicable. And to that extent, we have not interfered with the part of the calculation of the communication dated 11/6/2021. Only thing that minimum of the higher band, this for High Court employee, it will start a little above. Their minimum is 2 steps ahead. That's all. Sorry.
I will convey.
My notional benefit.
Then they will calculate it and recalculate and provide the benefits as may be applicable.
Notional benefit.
Because, Mr. Gogoi, our logic is, if that minimum of the basic pay is not available before pre-revision, the equivalent of that minimum will also be not available after revision. So you have to maintain the equivalence. That is the only logic, nothing else. The rest we all agree with you. Because otherwise it will become redundant. How can you come at 30,000 PB? You'll have to, it has to be corresponding to 17,900. When factually 17,900 of this category is simply impossible. So that is also not applicable, that's all. So wherever for them pre-revised it is applicable, from there, that minimum, we are retaining the same minimum. Petition allowed as indicated above.
Deep blue.
No.
Yeah,
No.
maybe we'll correct the language to some extent. If keeping the meaning same, we may correct the language. Sorry.
Figures where there are more zeros have been added
Yes.
as possible.
Yes.
Figure, you both of you please come and check up also. Figures we are not very sure.
More zeros have been added.
Yes.
It will be.
Figures.
No, a copy will be given to you before you sign, you check it up.
Yes. Figures.
We'll give a draft of the copy to you. And the only logic we are using is nothing different. Everything you are right. Only thing, the minimum also you are right. But the minimum of these people cannot be a minimum which is not available before revision. That's the only logic. All other manner of calculations made by the respondents in the final as well as in the High Court are no view is expressed, but the same are retained for the purpose of this order as it had been provided. Except for 30, you'll go to that 34. That's then you'll come to the figure of 47. When can you give it, Madam Chaudhary?
7. Except 7 and 8, Lordship.
Kali ki.
So can it be in the December, Lordship? December 18, Lordship. Monday, it's a Monday, Lordship. December 18.
December 18.
Monday, Lordship.
December 18.
Lordship, Monday. Lordship, I have a prayer. I have filed another CRP.
One on December 8th. As prayed for list again. We are not fixing date also. You get it. So you don't want us to hear it.
Lordship, it is partnered matter before your Lordship. only. Oh,
Release from partner.
no, then Lordship court or.
That's why you're saying.
Oh, I forgot.
Pass.
Lordship. Lordship, along with CRP 175.
That is another petition.
Yes. Lordship.
Same issue.
Same issue against counterclaim, Lordship.
What we intend to do, we'll hear on the entire thing. It's basically a jurisdictional issue. If it is this court,
Lordship.
we'll accept it. If the jurisdiction is not of this court, we'll allow you to go to the other court. In the interim, we'll give you some protection till you go there.
Lordship.
This is what we intend to do.
Cases, Lordship, both together, Lordship. CRP 175, 2023. Apply.
Mr. Mojumdar, you missed out today. It will be listed again. Before you make submission, why don't you think a little more deeper on its implication? Ultimately, why a litigant indulges in a litigation? To get some benefit. You are in an academic course before the court, that it should be 100% correct as per your academic concept. Or you want the relief sought to be attained? Which one? Both. Then we retain our order. We were recalling it. Let your petitioner suffer for engaging men like you. We can't help you. We are very sorry to say, Mr. Mojumdar, we can't help a litigant who engages a counsel who is so adamant and refusing to understand everything said to their benefit. We recall the order. Enough. Enough of you. Yes. Enough of all this.
I may be allowed to do other.
We will not allow you to. We have already passed the order. Do whatever you do. But we are feeling very sorry for your client. He'll miss his pension for the next few years. Can't help. When a lawyer is so adamant, simply refusing to understand, and that too you are factually and legally also wrong. You are factually wrong because there is a subsequent order providing that particular date. It will not have its effect before that. That line is also not wrong. So why do you play with the court's time for nothing and put the life of your clients at a jeopardy?
That is to fault of me, Lordship, litigant doesn't suffer.
Then why you're making him suffer then?
Lordship,
if he should not suffer. No, don't do all these things. See, there is a positive direction to pay pension to a man. He is getting pension for the last 3 years. Now you are trying to come on a review, saying that one line is wrong in that order. Even if I correct that line, the order remains the same. Plus, your submission is also wrong, that the line is wrong. That is also incorrect. Necessary. Be a little more responsible. List again. Hukon, I think we'll have to dictate the facts separately. 54 and yesterday's matter. I think we have to dictate the facts separately. The later part of the order may be same.
Same. Only reference may be made to the Dikka Yadav case.
The facts has to be stated in separate paragraphs, I think. It won't be, facts will not be same.
Not same. It is regarding law examination center change.
Mhm.
And here the examination.
The
Without
man made incorrect information in the application form, so therefore not made.
But amount has been deposited.
Mm. We'll list again one of these days.
Next week.
Next week, one again,
Friday. Friday.